Stephanie.
Good morning, Mr. Upshaw. Welcome to Centerville.
And good morning to you. And
Yes, sir.
Mr. Moss, you're charged with assault with intent to commit great bodily harm by strangulation and domestic violence. Allegation is that that happened in Three Rivers on November 10th. The complaining witness is your previous girlfriend, Stephanie Clemens. The first charge, assault, great bodily harm, less than murder with strangulation, is a felony. It's punishable by up to 10 years in prison and a fine of up to $5,000. Second count, domestic violence, is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Bond was set in the amount of $5,000 cash or surety, and you have posted the bond. They directed that you participate with community corrections. Yes. Are you presently wearing an ankle monitor?
No, sir.
Are you on some sort of other monitoring system?
I call once a week and check in.
All right. Well, because this is a felony, I don't have jurisdiction to take your plea here. We have to set it for what's called a pre-exam conference. And we're going to coordinate with your attorney, Mr. Upshaw, to see that that date works.
Your Honor, on behalf of Mr. Moss, Randall Upshaw, P number 43574.
Give me that P number again.
43574.
And you're directing your client at this time, obviously, to enter a plea of not guilty.
That's correct, Your Honor.
Mr. Upshaw, we do our pre-exams on Tuesday mornings, and we do the preliminary examinations on Tuesday afternoon. So the regularly scheduled date for this case would be a pre-exam next Tuesday, January 13th, with a preliminary examination at 1 o'clock on January 20th, if it's needed.
If I may, Your Honor.
Yes, sir.
Your Honor, I've spoke with my client because I have absolutely no discovery and in the dark on this matter. My client is willing to waive his right to have a PC or a preliminary exam within 21 days. I also would like to inform the court that I had a pre-scheduled, because I didn't celebrate the holidays, my wife and I have a pre-scheduled flight out of the country from the 15th through the 20th. I'm asking this honorable court if it would consider allowing my client to waive the 21-day rule and so I can also get discovery and set this beyond the 21 days for another PC.
All right, well, that's problematic. I don't have prosecutor input here. The victim advocate is here and the complainant is here. This often happens. In fact, it happens every time when out-of-area counsel come in. They've often got conflicts with their other practice. And certainly vacations are hard to come by. The defendant has posted bond. As far as I can tell, he's complied with all terms of his bond. Have there been any allegations of bond violations? All right,
Not to my knowledge, Your Honor.
I'm gonna set pre-exam for January 27th. I really don't like this, but at 8:30,
Speak up.
and the prelim, if necessary, for February 3rd. You did file an appearance, certainly, and I'm not sure what's up with the discovery, but we just did the arraignment. You should make contact with the prosecutor's office and get the information. I'm not sure exactly what all there is. Good morning, Mr. Knopfinger.
Morning, Judge.
Have you got something for me this morning?
No, not yet. Jim George.
Do we know what we're gonna do with Mr. Dusha Tellier this afternoon?
We should know by mid-morning, Judge. I've already spoken to Mr. Rivera about it.
All right, thank you. All right, Mr. Moss, let's talk about your bond conditions. Do you live in Canton Township?
Yes, sir.
What do you do there? What's your occupation?
I play professional basketball. I travel around the globe, playing for different countries.
All right, and so this is what league are you in?
Basketball. Right now, I have a contract coming up for the Tepe Copa League, which is in Mexico.
Well, you're gonna need to stay here. You can't leave the country. You can't even leave the state yet.
Mhm.
You don't have the court's permission to leave Michigan. You certainly can't leave the country. So delaying this is difficult for you as well.
Your Honor, if I may,
Yes.
if I'm attempting to, I sent some documents about his contract, and I'm attempting to talk with the APA at this time to see what resolutions he and I can make. Can you tell me your court, would you happen to know the APA that will be handling this?
I don't know. The person who authorized it, let's take a look, was probably, we're not that big. We only have 5 prosecutors. Maya would direct you to ask for prosecuting attorney Deborah Davis. The warrant was actually authorized by can't tell. Angelique Camfield. So she's the person that knows about it. She's very capable. She's a longtime career prosecutor from other jurisdictions as well. Angelique Camfield.
And I would just like, I apologize again.
That's the downside of not being here live and in person. You could just walk down the hall and talk to them. But as I said, this is just an arraignment. And so I'm not going to do anything without input from the prosecutor. So right now he can't even go to Howe, Indiana. He's not allowed to leave the state of Michigan. And where'd you play your undergrad? Miami?
No, I went to Buffalo, New York.
All right. Why are you wearing a Miami shirt?
Oh, well, right now they're on the winning streak. They just beat Ohio State.
Nebraska beat Ohio State last night in basketball. They beat the Spartans and they shouldn't have, but Spartans beat USC by 30 points last night.
Mhm.
All right. Good morning, Mr. Thal.
Morning, Your
Good morning, Mr. Sapanos.
Morning, Your Honor.
All right. So let's review. I keep getting disoriented, so let me stick to the point here. There are bond conditions. Let me find it. As far as I can tell, you've been in compliance.
Motion, which I'm inclined to do today. You're going to enter a plea of guilty to these charges, but instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which at this point includes outpatient treatment. You're going to follow the rules. You're going to refrain from the use of drugs or alcohol during the treatment period. Prosecutor has some things that they want you to do as part of their agreement to reduce this, and you're going to serve some time in the county jail. But if you do all the things that you're supposed to do, this case ends without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during the treatment period, then I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand that?
Yes, sir.
How old are you?
I'm 19.
How far did you go in school?
I'm graduated high school.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
Other than what we've talked about, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. Looks like on the second page, there's a signature by a blind defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Swift before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to 1 count of trafficking in marijuana. It's a 5th-degree felony. It's punishable by up to 12 months in prison and a $2,500 fine. We also have the aggravated possession of drugs, also a 5th-degree felony, punishable by up to 12 months in prison. The carrying concealed weapon, which is a 1st-degree misdemeanor, punishable by up to 180 days in jail. And if you don't successfully complete the intervention in lieu of conviction, then I can impose up to the maximum penalty in this case, which does include the prison, but it's not required. So even if you don't complete the ILC, I'm not saying that you're not gonna, but even if you don't, I don't have to send you to prison. That used to be the law. It's not the law anymore. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do?
Yes, sir.
Mr. View?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on March 12th of 2025 at the defendant's residence in Hamilton Township, Warren County, state of Ohio, the defendant did offer to sell marijuana in an amount less than 200 grams. He was in possession of methylphenidate, a Schedule II controlled substance, and he did carry concealed upon his person or ready at hand an operable firearm, that being the Taurus revolver listed in the indictment.
We didn't talk about it, and I don't remember if there was some discussion about it. Are we forfeiting and destroying the firearm that was involved in this, right?
That's specifically listed in the plea agreement.
Oh, okay.
He agrees he's going to forfeit the
I
firearm.
must have skipped over that. I'm sorry. Yep, there it is. All right. Anything on those facts, Mr. Swift?
No.
Mr. Hunter, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the right you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction, and I'm going to order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan. You're going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs. We're going to do Thinking for a Change. Is that?
Yes, sir.
All right. So we're going to do the Thinking for a Change program. I'm also going to order that you serve 90 days in jail. I'm going to give you credit for the 4 you have already done. Those 90 days are going to start within a week. So let's get started. You can report. I'm going to give you work release so you can talk to your employer, and as long as you can get to and from, get everything verified. I don't have a problem with you being out on work release. We're going to get 30 days of those jail days out of the way right away, and then we'll see how things are going.
All right.
Is there anything else we need to do? Anything I forgot?
Nothing else from the state judge. Thank you.
All right. I am going to order that the firearm pursuant to the agreement be forfeited and destroyed. And let's make sure that we follow the rules, Mr. Hunter, so that you and I don't see each other anymore.
Yes, sir.
Okay? All right. That's all.
Thank you, Judge.
compliance with the terms of your bond. Do not have any contact with Stephanie Clemens. Clemens is a three-over's name. I think I knew her grandparents. Did your grandparents live on Michigan Avenue? Yes. Nice people. They're Jehovah's Witnesses and landlords. All right, no contact with Stephanie Clemens. Comply with all directives of the Community Corrections Board. Shall not leave the state of Michigan. No firearms, no assaultive or threatening behavior. Now, the bond could be amended if your lawyer and the prosecutor talk with each other and agree to some conditions. When would your contract start with the Mexican League?
I was hoping for, well, they're hoping for me to be there by January 15th.
Well, it ain't gonna happen unless something else happens.
Yeah, I've updated them on the situation.
For now, your next court date is January 27th at 8:30. I want you to comply with the conditions of your bond. Mr. Upshaw, my recommendation would be you contact the prosecutor's office and ask to speak to Angelique Camfield. She's the person that authorized this. She has charging authority and plea authority. Let's assume that the matter is resolved with some sort of a negotiated plea, even to a domestic assault. As you know, there's a deferral statute that could apply to this, but I don't know enough about it. Reading the affidavit, this is bad. It's scary and dangerous. And so I don't know where this case is headed. Mr. Moss, I'm going to have the bailiff take you out to the court office, and they're going to give you a notice for your next court date, which is January 27th at 8:30. And if needed, the next date after that would be February the 3rd. If there's some change in this, we'll discuss it. But this isn't a traffic ticket. This is a serious 10-year assault with intent to commit great bodily harm felony charge. So it isn't going to go away with a swipe of a hand. This is some serious stuff. So.
This is right. Represented by Mr. Acella. We have Mr. Harris from the prosecutor's office, and Officer Wilford is here from probation. We are here today for a final violation in the 24 case and a pretrial in the 25 case. It's my understanding that Ms. Moses is going to enter a plea of guilty to the escape charge in the 25 case. She is also going to admit that she has violated the terms of her supervision, and we're going to set this for sentencing in a couple of weeks. Is that accurately stated?
Yes, Your Honor. Yes, Your Honor.
Ms. Moses, I know we've been through this once before, but I want to make sure that I have a clean record in this case also. How old are you?
37,
How far did you go in school?
9th grade.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Prenatals. That's it.
All right. Are you taking anything that would interfere with your ability to understand what we're doing here today?
No.
Are you a United States citizen?
Yes.
We've had some discussions about your case, and if you enter a plea of guilty to this charge, I'm not going to sentence you today. We're going to set this out for a couple of weeks. We are still exploring what our options are going to be. We have, essentially, as I see it, Ms. Moses, we have three options that are available to us in this case. The first option is that I send you to prison, and then I release you from prison into some sort of step-down lot facility. Stage 2 would be that I send you to a community-based corrections facility, someplace like the Monday program, something like that. I do recognize that both of those options separate you from your baby. I get that. And then option 3 is exploring somewhere where you and your child can go together. I'll be honest with you, Ms. Moses, I don't know which way I'm going because we've had sort of a lot that we've had with you in the short time that you and I have known each other. It's only really been a year. Seems like a lot longer than a year. I really honestly don't know where I'm going in this case. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes.
Did you review this with Mr. Ocello before you signed it?
Yes.
Are you satisfied with the representation that you have received in the case?
Yes.
You're going to enter a plea of guilty to one count of escape. It's third-degree felony. It's punishable by up to 36 months in prison and a $10,000 fine. It also carries with it an optional period of post-release control of up to 2 years. There is no mandatory prison in the case, so I don't have to send you to prison. I can put you into my community control program. Your rights really haven't changed that much since we talked about them last year. You still have the right to make the state of Ohio prove that you're guilty of this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes.
Mr. Harris?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about May 31st of 2025, while under the supervision of the Warren County Adult Probation Department in Warren County, Ohio, the defendant, Tiffany Moses, did remove her court-ordered GPS monitor and violated the terms of her community control.
Anything on those facts, Mr. Ocello?
No, Your Honor, thank you.
Ms. Moses, did you hear those facts?
Yes.
Do you admit they are true?
Yes.
Do you understand the right you're giving up by entering plea?
Yes.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. We are going to update the PSI, set this for sentencing in a couple of weeks. Here's what needs to happen, Ms. Moses. One of two things is going on here. One possibility is that you have a lot of issues going on. And I think that's probably true, that you do have a lot of issues going on with your pregnancy, with the uncertainty that goes along with that, your situation in the jail. But I also think, Ms. Moses, that you do not always tell the truth about what's going on, and you try to manipulate the surroundings to get a better outcome for you. That needs to stop. You need to start being honest with folks about what's going on, and that honesty will give us the opportunity to make some headway in the case. If you still want to play the same kind of games that got you into this when I sent you to the program and you cut off and all that, if you want to continue to play those games, I will send you to prison. I promise you that. And I understand that you have a child. I mean, I do. I understand that. But I also know that you are no good to this child as a mother if you were going to continue living the life that you are leading. So you need to get your act together and show me that you are interested in changing your outcome. Otherwise, this just becomes a punishment case. And you don't want it to become a punishment case, because that means that I have to send a message to everybody else in the jail. If sending a message to people in the jail, what that means, Ms. Moses, is I have to sentence you more harshly so that people over in the jail, they don't do the same thing that you just did. So when I put people on a monitor, it's an act of faith. It really is. And people think, oh, well, you know, I have this monitor out there and it keeps people safe, or it keeps me in line, does all those things. Doesn't do any good if somebody cuts it off right away. So what I would really encourage you to do, Ms. Moses, is do some hard thinking about playing the long game in this and figuring out what you want. And hopefully we can get there. Officer Williford is going to be exploring both options in terms of a place where you can go with your child or a place that you are going to go without your child. She's going to explore both of those options. We're going to decide where we're headed in a couple of weeks. All right. Anything else?
No, Your Honor.
All
Thank
right.
you.
That's all.
Proud of you.
On the 24 case, there's no dispute that she violated the terms of her supervision, right?
I don't believe so, Your Honor. I think the basis was the new charge.
Okay, so we'll set that for disposition, but you can go ahead and send me an entry where the court finds that she has violated the terms of her supervision in the 24 case.
Okay.
All right, that's all.
Thank you, Your Honor.
You go out to the counter, stay in contact with your lawyer, Mr. Upshaw. He'll get the police report. I don't know if there's 911 tapes or photographs or videos or whatever evidence that is. He'll get a copy of it. Stay in contact with the conditions that you've got from community corrections. All right, you're good to go, sir.
Thank you, Your Honor.
Thank you, Your Honor, and have a good day.
All right, thank you. Mr. Upshaw, I look forward to meeting you in person.
Likewise.
All right, thank you. Okay, we were plugging away here. Patrick Jones from the city of Three Rivers is a trespass. He has failed to appear. Well, he's got other problems. I think he's homeless. We'll go in order to show cause. It's always a little tricky to try to do a order to show cause on someone that doesn't have an address, but we'll try it first. Mr. Paul, what have you got for me this morning?
I've just got one pretrial plea, Your Honor.
All right, who's that on?
Samuel Barnett.
All
I
right,
have a plea sheet.
all right, why don't you bring that up? And they did bring me Pablo Pena. Good morning. Are you Samuel Robert Barnett?
Yes, Your Honor.
All right, this is a pretty good plea offer for you. This is file number 252279OT. It's an ordinance case and that it was written under White Pigeon Village Ordinance. The White Pigeon Village attorney, one of the assistants in the, I call it the Sieber law firm. We'll call it the Fall law firm, which it originally was, is here on behalf of the city. They're going to dismiss the charge of no operator's license, which is going to save you 2 points, and it would go on your driving record. And they're going to dismiss the no proof of insurance, which is going to save you $150. And you're going to enter a plea to a charge called allowing another to violate the motor vehicle code.
Yes, Your Honor.
That's a misdemeanor. It's punishable by up to 90 days in jail. Doesn't carry any points and it doesn't go on your driving record. It's called allowing another to violate the motor vehicle code. Do you understand the charge?
Yes, sir.
And other than that plea agreement, where these other charges were dismissed for a plea to that charge, did anybody promise you anything?
No.
Laura, I've run out of allowing another to violate the motor vehicle code judgments. If you could get me some. All right, you were here when I went through the advice of rights, so let's take a minute. This is a misdemeanor. Do you understand that by pleading to this misdemeanor charge, you're going to give up your right to have a trial in front of a judge or jury? That will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. You could ask me to appoint one, or you could hire one of your own choosing. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
Were you driving a car in White Pigeon on November 6th?
Yes, sir.
Where were you going?
I was coming home from work,
Where do you work?
Ox Industries.
All right. Why is your license suspended?
I moved up from Indiana and I have to take the permit test, and I have a learning disability. I passed the signs, but I didn't pass the multiple choice.
Your Honor, if I may, I don't think it's suspended. I think it just doesn't have a license.
Doesn't have one,
Yeah.
okay. All right, well, this won't affect your ability to get your license, so keep plugging away at it. Eventually you'll get over the hump. How'd you get here?
My aunt brought me in.
All right, it's good to have friends. All right, fine's $100. There's a $75 crime victims' rights fee and a $50 state minimum fee. And let me say this, when you're driving around with no insurance, you get an accident, you're gonna get sued by the other guy's insurance company for $20,000. Plus, when you get a no insurance, it kills your insurance rates. So you got a break with the village dismissing that charge. Anyway, you owe me $225. Let me see, you weren't on my cheat sheet. I don't know if you owe me money now. There's Barnett's from here in St. Joe County. Are you one of them or are you from Indiana?
I'm from around here.
Because they were Colon Barnett's and there's some out in my neighborhood, Park Township.
My dad's went in front of you a couple times.
Who's your dad?
Andrew Barnett.
Okay, yeah, I've known him for a long time. Well, let's see how you're doing, sir. There's another Sam. Oops. Barnett. What's your middle name?
Robert.
Yeah, you got nothing. Samuel Leon Barnett, he's got some, but he doesn't owe me any money either. All right, well, you're in good shape. I'm gonna give you 30 days to pay that $225. Can you do that?
Yes, Your Honor.
Okay, very good. I always joke with Miss Geschwint that when she comes on here, she drew the short straw. I guess today you drew the short straw, but at least the weather wasn't bad.
I did. She is in Lansing for a Court of Appeals hearing today.
Oh, well, good for her. I'm gonna make that due by February 10th. That ought to be enough time to pay it. All right, good luck, Mr. Barnett.
Thank you, Your Honor.
Oh, thank you. See you again.
Thank you, Your Honor. Have a good day.
Thank you. Keith, we do have an extra customer this morning that I'm gonna try to do. Mr. Cody Matheny got arrested on a probation violation last night. Cody Matheny, and we'll do him in a minute. Which case are you folks here on? All right, what's your name, sir? Kettle Hut. Mr. Kettle Hut, I don't know if you're on my docket for today. John? Ernest. Let me take a look. Oh, you're supposed to be next door. Yes. You're charged with harboring felons. Your attorney is Mr. Knopfinger. He stuck his head in here, but yeah, your attorney is out there. Ask the bailiff and let them know you're here. All right, let's talk to Mr. Pena, who's a day late and $1 short on a drug charge, but we'll deal with that. Good morning, sir. You're Pablo D. Pena?
Yes, I am.
Mr. Pena has a bench warrant out for his arrest. His girlfriend had called. Oh, it's just an outstanding warrant. There's no bench warrant.
Yeah, I don't believe he's ever been arraigned.
Deputy Zinsmaster reached out to Prosecutor Davis and said he can turn himself in at the courthouse. That's not the protocol. He's supposed to turn himself in at the jail.
Your Honor, I believe he qualifies under 762.10D. He's able to present himself at the court. I don't believe that this is a enumerated charge where he's not able to and would have to present himself at the jail like an aggravated case or a domestic violence. I think it's just a drug charge. So it would be appropriate for him to bring himself to the courthouse. I think that there was some confusion, mix-ups about that. So I talked to him yesterday.
That's this case. It's got an unpaid fine on a driving suspended. Pled guilty to driving suspended. I gave you a $250 fine by July 31st, 2020, or 4 days jail. You made a payment. You made a payment. Made a payment. And gave you till March. Payment. I guess that's mostly paid. You're set for sentencing on a charge of no insurance. Pled guilty to violation of the motor vehicle code, and the original charges were dismissed. I set it out 90 days to see if you paid your existing fines. You're set for sentencing on February 17th at 9 o'clock. I don't know whether you paid on your existing fines or not.
Well, actually, excuse me, I was going to set up a payment plan today, actually, while I was here.
Well, I'm looking real good. That was in November.
Yeah, no.
Maybe I ought to just put you in jail right now. I gave you a 90-day break to start to pay on it, and you didn't do anything from November till January.
I've been going through a couple things.
Yeah, you've been going through some things. All right, let's take a look at this. That's very disappointing to me.
How much is the fines? Yeah.
I don't even know. You just walked in off the street. I didn't have any preparation of this. So
After that day, I went to the office here in the court, and they told me that they said that I owed a whole bunch, but then they looked closer and told me that my name is in there twice.
Yes,
like 3 brackets, it's twice, so it looks like 6 fines, but it's really,
it's not.
okay.
That is true. You're in there twice,
You explained it to me, but
but you owe something, and so far you haven't paid anything. But let's take a look at this. 2463. This is alleged that the way back in July, so this isn't imminent, that you did possess methamphetamine as a second or subsequent offense. That warrant was authorized on November 24th by Prosecutor Robert. The way it's charged, it's a felony punishable by up to 20 years in prison. They allege you got stopped at 131 on Broadway, where everything seems to happen, at Culver's parking lot. Pena was found to not have a valid license. He consented to the search of the vehicle. The registered owner of the vehicle arrived and said that she wanted the vehicle searched for narcotics. Used needle and a tin foil with burn marks, commonly used to smoke methamphetamine. Pena stated he used methamphetamine and heroin. All right, well, what it is a paraphernalia charge and no insurance. So it's a trace amount and some stuff in the car. All right.
I actually recently started the Suboxone program also. So
Who's helping with that?
what's the Work at Health?
Work and Health?
Work at Health, yeah. I call and do my appointments on video and keep in contact with it like twice a month or something. But
I'm not familiar with that program, but it sounds like a good one.
it's working.
Well, it works for opioids, but it doesn't work for methamphetamine.
True.
They don't have a Suboxone corollary for meth, or the world would be a better place. All right. You're going to need to get printed and mugshotted. And set bond in the amount of $2,500 PR. Defendant needs to be printed. And mugshot.
Will you be checking out with pretrial service or community corrections as well, Your Honor? Not off the bat.
You're recommending that?
Sometimes, sometimes people find it helpful if they're doing things like Suboxone and stuff, in my experience, but it's up to the court if he does.
All right, I'll do that. They can supervise that. It is a second or subsequent offense. I'm going to set pre-exam.
Okay.
This happened in 3 rivers, but it's by the county officers. So Mr. George is eligible to be his attorney. Set pre-exam for 2/13/26 at 8:30 and 2/20/26 at 1 for preliminary examination if needed. All right, I'm going to send you out to the counter. You can do his fingerprints here. He's going to need to go to the jail to get a mugshot. He's got to sign a bond form. We're going to refer you to community corrections for supervision. Glad to hear you're on the payment plan or on Suboxone. If you don't pay on the other stuff, I'll just put you in jail when I see you in February. You got another no insurance with this. But this was in July, so that may be the one you're paying on.
I believe it is, yeah.
Yeah, you didn't get another one. It's the old one. So let's get this taken care of. All right, you go to the court officer. You got some things to do here.
Thank you.
All right, Miss Felicia Slater also is a no-show. She's been struggling for the last couple of years. She's charged with trespass. She may also be homeless. She wasn't, but she's been going downhill. We'll do a order to show cause first. Anybody sees Felicia Slater, tell her she needs to come in here and see me. It's only a trespass charge. She's got lots of unpaid fines and costs, but she's a sit struggle. She got $1,142 unpaid fine and costs. Hello, Deputy Tafflinger, Judge Middleton calling. Don't you wish you were here? Okay, well, you're there, so thanks for helping me. Could I see Cody Matheny? All right, thank you. Bye. I said, don't you wish you were here? He said, yeah. I hate to lose Michelle. We're going to lose her. I think she'll be here till next Tuesday, but last I'll have with her is this week. She does a great job.
Is our duty so cushy they make them rotate through?
Yeah, they make them rotate through. And so some guys actually bid back to the jail, but generally they rotate them for a couple of years and then rotate them back into the jail. Hello, Dan. We're about to do Cody Matheny. All right, thank you. Bye. Mr. Matheny was charged with a malicious destruction of property, a kind of a strange case where he shot pellet holes in his neighbor's window. He was put on a probation, and he was up and down. We've had some probation violations, and then he just sort of took off. So Daniel issued a bench warrant. I set no bond. He was supposed to do some weekends. I tried not to do a bench warrant, but he had to do 27 days credit too on weekends, and he just quit showing up. So my intention is to just order the rest of the balance of the time straight and revoke his probation.
Somewhat remember the case. Hey, Heather, how are you?
He's a nice kid, but he's got some problems that he's not addressing.
Oh, looking slick. Yeah.
He's given Daniel more gray hair lately.
I can verify. Yeah, definitely. That or the dyes wearing off.
That and our friend from yesterday.
He's a nice kid, but he's definitely got some mental health issues for sure.
Natalie is giving Dan some gray hairs too.
Oh, for
Hey,
sure.
BB gun guys, maybe they just watch Christmas Story too much or something. It's Christmas time and out there with the Red Rider.
I don't think they're going to tell me how she got him either. Because I asked Army and she's like, well, I don't know. Yeah, we're still looking into it. And I'm like, well, they didn't really tell me last time. I had to hear it through the grapevine. Apparently,
Well, don't talk about that on here, but
oh, you got me on. You know, so
Well, we're always live.
when does Priscilla come back?
I think at the end of the month.
Well, we're gonna get Priscilla back in the probation department. We filed a new girl. Good morning.
Morning.
Good morning. Is this Miss Horvath?
Yes.
All right. What? Horton, yes. All right. Yeah, Horvath is somebody else from girls. Did we resolve the case?
Yes, we did.
All right, very good. Thank you. I'm gonna take care of this in custody guy and then we'll do yours. Are you pinched for time next door?
No, I have a 10:30.
All right. Well, you held up your end of the deal. You showed up today, and so that's good. Daniel, how much time does he owe?
You just gave him 2 days. And then we've not been able to schedule it. And then he called me and told me he was traveling around the country.
Well, I gave him 27 once.
Oh, that's probably up front.
I know, and then so he did that. So he just had 2 days and failed to do it and then went off the grid. I told Daniel, my proposal, just order the days straight and revoke his probation or reserve the restitution.
Yeah, and I mean, depends on the battle we want to pick, I guess, but technically he was pulled in before midnight, so that jail counting, he'd probably be done now.
Well, he's not. All right.
Must want to make sure he does that.
Good morning, Mr. Matheny. This is Judge Middleton.
Morning.
This is file 242193FY. In this case, Mr. Matheny, you were originally represented by attorney Paul Gibson. Here with me in the courtroom is your probation officer, Daniel Frazine, and Mr. Keith Stickley from the Public Defender's Office. We struggled in this case right from the get-go. You were placed on probation. We had a couple of probation violation hearings. You got 27 days once. This last probation violation, I gave you 2 days jail. You were supposed to schedule it to do it, and then you left the state or something. How did you come to get arrested last night?
I was just walking to the store, trying to keep doing some shit, and they pulled me over, and yeah.
So you moved back to Three Rivers?
Yes, sir.
All right. You went on the road or something. Where have you been?
I don't know.
Well, I'm gonna get this over with. I'm gonna order 2 days jail credit 1. I already ordered the 2 days jail and you didn't do it. So you got 1 day to serve. I'm gonna revoke your probation and get off your back.
How does it get revoked when I paid my fines? I paid my fines, then you gave me a probation violation and revoked me? It made me look, I don't understand that.
Well, I'm getting off your back. You're gonna do 1 more day in jail and I'm gonna reserve on any unpaid restitution. I ordered that you do 2 days in jail and you went, I lost track of you. You never did the 2 days. I've already ordered it. I'm just gonna give you the 2 days, credit 1. You'll get out tomorrow. And you won't be on probation anymore, although there may still be a attempt to collect on the restitution.
He's paid in full, Your Honor.
Oh, he's paid in full?
Yep, he did pay everything in full.
All right.
And just to clarify on the record, Your Honor, because it is a little bit ambiguous. I don't want to look like he's got a right to a hearing. He's already had all that.
Yes.
He's already sentenced.
He's had a hearing,
He
he's
just has
been
to do it.
sentenced, he failed to
Understood.
show
Thank
up
you.
for the sentence. I'm off your back, Cody.
Yes,
Good
sir,
luck.
thank you.
Hope you have a better year this year.
Good
All right, good luck. He doesn't know where he went, he just didn't go to jail. As Daniel said, he's got issues that he's not really addressing, but we haven't been very successful at trying to deal with it, but
Can we got that one off too?
sure. So I can drop all these.
Okay.
Thank you, Daniel. I wish that kid good luck, but he's gonna have to deal with some of his issues.
Family too, trying to get him out, but
Yes. Ms. Horton, would you come up and have a seat?
I will. Are you
Right
across
over
the
here
street?
with your lawyer.
Over here, yeah. And do you have something for the no contest, Your Honor, or do you need something?
I think I've got something.
Okay. And I did clear this with Attorney Stoll, and she can come in if needed.
All right, the case we're addressing is People versus Nevaeh Maria Horton. File number is 252100SD. This matter was set for an attorney pretrial last Friday, which would have been January the 2nd. We had a lot of cases set that day. We had 10 or 11 drinking driving cases. The defendant didn't show up, so I called her on the phone while her lawyer was here. And we agreed that she would be here this morning to meet with her lawyer and have the attorney pretrial. So she held up her end of the deal. She is here today, and so is Casey Strong, her lawyer. She's charged with a complaint that alleges that on or about 7/17 of 25 in White Pigeon Township, she was operating a vehicle with a high blood alcohol content of 0.1017 grams or more. That's used to be called the super drunk statute. It's a misdemeanor. It's punishable by up to 180 days in jail and a fine of up to $700 and 6 points in the suspension of your driving record. Ms. Strong, what's the plea offer here?
The offer is operating while intoxicated first offense as a no contest plea for lack of recollection.
All right. The lesser charge, operating while intoxicated, is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. It does carry 6 points and requires that your license be suspended. Do you understand?
Yes.
Anybody threaten you to get you to plead to that charge?
No.
or promise you anything other than the reduction of the charge?
No.
Now, by pleading no contest, you don't admit what happened, but you also don't deny what happened. You allow or accept that a conviction would enter. This affidavit shows that you were quite intoxicated. You drank New Amsterdam vodka and Dr. Pepper, probably a name for that. And then you drank some twisted teas and smoked some marijuana. You were actually in a traffic accident and were injured. They took your blood and it came back as a 0.204, which is over the limit for operating while intoxicated. That's over 0.08. It's quite intoxicated. We get lots of people with high blood alcohol levels, and they say, well, I had 2 beers, or someone told me the other day they had 3 butterscotch shots.
Yes, I do not intend to lie. I knew I was drunk at night and I intend to take the consequences for my actions.
And I appreciate that. You were, it takes a lot of alcohol to get that high of a blood alcohol level. And it also takes practice. You can't just go get that drunk without having a little practice. Now, the no contest plea, this is the quintessential type of case. People are in a traffic accident. They don't have a recollection of what happened. And they say, well, I don't admit it, but I also don't deny it.
I just don't, I don't remember enough for.
All right, well, that's fine. So you're pleading no contest to this charge?
Yes.
And you accept the factual basis from the affidavit of probable cause? All right, Ms. Holt. Now, we were very busy on Friday. We didn't finish until about 20 to 1, but we would have fit this in. I set your lawyer for a bunch of sentences, and I think that day's already crammed too full to put this in there. So
I can make it smooth.
What?
I can make it smooth.
Let's see how much is in there. No, I only have 3 probation agents.
Oh,
so
yes.
I can't do 4 screenings on the same day. In fact, right, I'm gonna be shifting things. But let's take a look and find a date that doesn't work very good for you. Yeah, let's see what I got. Yeah, I've got 3. I got Alexander, Westfall, and Camp, all for February 11th. You got an all-female group that morning. As I said, we had 11 cases. We did 7 of 10. But let's go out a little farther. Rather than I like, but V25. Are you available on Wednesday, February 25th?
Absolutely.
Ms. Horton, things have changed in your life since this accident happened in July.
Yes.
You went to the hospital, you had some treatment. I thought you were also, had you done some rehab or some other sort of alcohol treatment?
Yes, I was in I'm still in AA. And I went to the hospital because I broke my leg.
Are you on probation or parole anywhere?
No, I've never been in trouble.
Well, I'm glad I didn't read about you in the newspaper as an obituary. Set this for February 25th at 11. Attorney Casey Strong. Ms. Strong, I appreciate your accommodation here. You saved your client getting arrested on a bench warrant. We made it work. We had more relaxed time to take the plea. She's accepting responsibility. We'll get it set for sentencing, and that's good for everybody concerned. All right, Ms. Horton, what's your occupation right now?
I'm a healthcare provider with ADAPT.
Yeah, you told me that each time I talked to you. I think you told me that on the phone also. Well, all right. This is going to suspend your driver's license.
Yes, I know.
And so you need to prepare for that. That'll happen shortly after.
I don't have a license.
All right.
So someone already takes me to work.
Okay. Are you still in Edwardsburg?
Yes.
All right. You take this form out to the counter.
Thank you.
All right, Ms. Strong, thank you. I'll see you in February. Oh, that was a good case to get resolved. John, I'm not exactly sure what we're doing with Mr. Harvey.
This was a deferred sentencing to see if they were going to reduce it to disorderly if we.
Yeah, so I guess you need to check in with the prosecutor. I haven't had any further input. That's my hope. He's in the program. He's doing a good job. I've had to hit him in the head a time or two.
He had a hiccup and I guess he got jail sanction early.
He did. He took his lumps, and Autumn likes working with him. I'd like to keep him in the program.
You let down the prosecutor?
Yeah, please. All right, Mr. Harvey, we're going to take a short recess here. Let's see what. Oh, the famous Abigail Stoll is here. Abigail, thank you for the help with that last case. We weren't able to do it on Friday because that girl didn't show up. I called her on the phone and woke her up, but we got her in here this morning. Casey was here, you were here, she pled, she's set for sentencing. We got the case resolved, so thanks for your help. We also got to deal with Thomas Morales. James J. Harvey, file number 25366 SM. Mr. Harvey was charged with domestic violence that occurred on February 28th of 2025, almost a year ago. He's here with his lawyer, Mr. John Bush. The matter had a lot of twists and turns in it. The defendant pled to domestic violence first offense. He pled no contest, and he was placed under the supervision of pretrial services in June, set for delayed sentencing for December 15th, and it got moved to this date.
Sorry, I have one question. Supervision.
Yes. This was there's the regular old deferral statute, 769-27A or whatever it is, that allows for deferral of domestic violence. This was a prosecutor thing where they agreed to just delay the sentence. Yeah.
Well, I was just gonna ask for Matheny. Are you doing anything with his fines and costs since you're revoking probation, or do you have that?
No, Daniel says he's paid in full.
Oh, okay. That's good enough for me then. Thank you.
I would state, since that date, Mr. Harvey has been participating in the sobriety court treatment program. And as Mr. Bush put it a little bit ago, he's had some hiccups, but he's presently in good standing and complying with our protocol. And he's doing a lot better than he was. My also opinion is he and the complainant in this case, Ms. Wilma, are on good terms. We've been in contact with her in the course of this. And so I guess this is the time to find out what the prosecutor wishes to do with this. At one point, I think the thinking was if he complied with the terms, we went all the way from February to June and from June to January, that the prosecutor would reduce disturbing the peace. Ms. Stoll, I think you were involved in this at the front end. Was it you or was it somebody else?
I don't think it was.
Was me? All right.
I believe it was Miss Davis too.
All right, maybe it was Prosecutor Davis. What are your marching orders here today?
Well, it's clear that the defendant has some issues with alcohol. It's my understanding that he's been in sobriety court for about 6 months now. On the night of the assault, he had been drinking as well. I wouldn't recommend any jail time. I believe 12 months probation would probably serve the defendant best.
He's already on probation. The question is whether that would reduce this from a domestic assault to a disturbing the peace.
I don't see any notes in our file indicating that that's something Ms. Davis or Ms. Campfield wanted to do. So I can't make that determination today.
All right. Well, I'm going to see him tomorrow. He's going to be here tomorrow afternoon. Mr. Bush won't be here, but Mr. Knopfsinger will be here. Okay. And let's continue this till tomorrow at 2. And then you can confer with Ms. Davis and see what we're going to do with it. Are you missing work right now? You're not plowing any snow right now.
No.
And it's too cold to do a lot of the stuff that you're doing.
Can I at least put my 2 cents
Yes,
into
you
what's
can.
going on? And I no problem with Mr. Knopfsinger handling it tomorrow. That's fine. But I just had some updates for the court.
All right.
Much of which you certainly know. Mr. Harvey wanted you to know that he's in sobriety court. He's going to AA. He's going to Pivotal one-on-one. He works with Bradley Baker. He's in the sobriety court group. He sees Pivotal twice a month. He's been doing the Zoom sobriety court. He maintains his employment with Henschel Brothers, which is a little on and off with the weather, but right now it's primarily snow removal. He and Kylie are getting along. He says they're not living together, but they have a good relationship. He acknowledges that he had a relapse early in the case. He could not tell me the exact month, but he thought it was the end of the summer. And he did 2 days in jail. He also admits that he missed a Zoom meeting this week. Or last week, he worked 36 hours straight snow plowing and fell asleep and didn't make a meeting. So in full candor, he admits that. I think that would have been a Zoom meeting.
With Spencer's group.
Yeah, that would have been probably last Tuesday night.
I shared to me, he fell asleep with a phone in his hand after working.
All right, well, we'll explore that more tomorrow.
So he's asking.
So you got an interlock in your truck?
Nope. My brother's plowing.
What's that?
My brother's plowing for me.
Okay.
It's like teaching him how to mow almost.
So you're riding in the truck with him?
Yep, when I shovel.
Okay.
Got to switch roles.
Okay.
He's asking that the court resolve this case with the disturbing of the peace. He feels he substantially complied with.
All right, I want to continue this to tomorrow, which will be 1/7/25 at 2:00 with sobriety court. that means you're gonna have to come in live, but if you miss Spencer's group, you probably have to come in live anyway.
Right.
So Abigail, I'd ask if you just touch base with Ms. Davis, relate what you just heard from Mr. Bush. I know from my contact with him and Autumn's contact with him, he and Miss Wilma are on good terms. They're not living together. She's supportive of his sobriety. She likes the fact that he's in the program. He's always polite and respectful. He's had some relapses, but he took his lumps. He's back in the program. So I'm not exactly, this was early in Miss Davis's tenure. She took over in January. This happened in February. And then let me look at my notes rather than what's in the ROA and see what was said. Because I wasn't a big fan of these kind of deferrals. Because they're a little bit open-ended, but I didn't feel bad because I had a handle on him with sobriety court. Prosecution would take a disturbing the peace per Angelique Camfield. Prosecutors feel lack of plea agreement compliance. Need to reset this sentence. I'll have contact. So that was December 15th. Ms. Canfield indicated they would take a disturbing the peace.
You know, I'm defense attorney. I think she said
on
just the
June
opposite.
19th, bench trial set, plea entered, Debbie Davis and John Bush. John Bush will report on the new case per Miss Davis. Pleaded DV first, delay sentence for 6 months under statute. Defendant to take counseling, sign release, would reduce to disturbing the peace. So both Miss Davis and Miss Camfield said they would do that. As long as he's compliant with sobriety court probation. The things that Mr. Bush related, he's in Spencer's group, he is attending AA, he is doing individual and group counseling through Pivotal, and he's testing on a regular basis. All right. We'll deal with this again tomorrow. And
Mr. Harvey, you're comfortable that I won't be present tomorrow then? So okay.
He's got a good relationship with Mr. Knopfinger. He's our sobriety court public defender. They work together, and I'm comfortable with Mr. Knopfinger.
Thank you, Judge.
Representing him. But all right. I'll see you tomorrow at 2.
All right, thank you.
All right, thank you, Abigail.
Thanks, Judge.
Yep.
Now, I had a dude named
Person should take total readings.
Injun.
Yeah.
Okay. Court does call the case of Barbara Woods versus Tanya Anthony.
Good morning, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
And
She's also.
Good morning.
oh, she's on the phone.
Yeah.
Okay. Say your name
Can you
again,
hear me?
please.
Tanya
Yes, ma'am.
Anthony.
Okay. Is Jermaine Napier there?
No, he's at work.
He's at work. Okay, very good. All right. My understanding is there's an agreement on
There is indeed, Your Honor, and I'm also happy to report to the court that Ms. Anthony did drop off the $900 payment referenced in the agreement. So this matter is fully resolved. The account is paid in full.
It's paid in full. Okay. So she's paid everything and I'm signing this, but everything's all done.
Correct.
Is that correct, Miss Anthony?
That's correct.
Okay, what I'm gonna do is I'm gonna enter this conditional order dismissal. You do have 3 business days to think about it since I'm signing this. And if you believe that there's some legal reason, some confusion, or some right you didn't assert, you'd have to file a motion with the court within that time frame for the court to set it aside. Do you understand that, ma'am?
Yes.
Okay, I don't expect to hear from you, but if I do, you've got that time, okay?
Okay, thank you.
All right, thank you. And you take care of yourself.
You too.
Is that it for you?
That is it for me today, Your Honor. Thank you.
Wonderful. All right, take care.
Take care. See you Friday. Bye-bye.
Yes, ma'am. Who is this? Jerome versus Cassidy.
Extra high if you get.
They, well, hold on. Do I have everybody?
Sir, Cassidy is in Zoom.
Got it. I got counsel for the parties, Jerome's. I have counsel for Jerome's and for the Cassidys.
Yes,
Right.
Your Honor, I think we're appearing on behalf of the Jerome's plaintiffs in this case.
Yes. No,
Oh, okay.
really? Boy, I haven't followed that along after the last 30 hearings. I get that. Okay.
I'm new. So.
Yes, I do. Well, and that's what I'm saying. I said, that's not Lloyd. So I don't know. But I was informed you're representing.
Eric and Paula Cassidy. That's
so you're representing both.
I am representing.
Okay, good. So that has all come together.
I don't have anybody for Cambridge.
Just a bundle of sunshine.
A ball.
A ball of sunshine. Okay, I don't have anybody for Cambridge. And trying to recall, is Miss Tepe gonna be here?
I'm checking now, but I don't believe I have any communication from this. And she's normally pretty good about communicating.
It's nice of you to say it that way. So do any of you know with reference to Miss Tepe?
I have not heard from her regarding this particular motion, Your Honor. We did serve her with the motion, and she's been otherwise in communication with me on other matters as recently as I think yesterday.
I haven't heard from Ms. Tepe.
All right. So is everybody prepared to go ahead with your motion then?
Yes, Your Honor.
Okay, go ahead.
Okay, thank you, Your Honor. The motion before the court is to the court to obtain concurrent jurisdiction over the monetary claim which exceeds the court's limit at $25,000, or in the alternative that the damage claim for unpaid rent be removed to circuit court. At the time of filing of the motion, it was all parties, and it was all parties through counsel's preference that this court keep jurisdiction to hear the monetary claim, given the long history of this case and the court's intimate familiarity with what's going on and how we got here. And it was thought amongst counsel that it was judicially prudent to keep it here instead of starting over in circuit court with the new judge. And so and the court had expressed in the past its willingness or openness to doing so. So I filed a motion to bring that to a head so we can move on. The parties have spent an inordinate amount of time trying to settle this case. It's not happened, and we're ready to move forward with ultimately what is a rent issue from landlord's perspective. So we'd like the court to obtain jurisdiction if the court is willing, and also to move forward with trial. And I understand new counsel wants to clean up some pleadings, which we would be amenable to as well.
We have a position on this.
Thank you, Your Honor. Go from here, wherever.
Either.
First, I will say I appeared yesterday on behalf of the Cassidys.
Yes.
I'm relatively new to the case. As I see it from the docket, Cassidys have not been able to file a response to this motion. I also know that Ms. Tepe is not here. Frankly, I think it would be helpful if we could continue this motion to just next week. I can file something by the end. Of the
Okay,
week.
so you need time to talk it through with your clients, figure out if that strategically is what you may want to do, and then do.
That would be very helpful.
Okay,
And while
well-
I'm making that ask, it'd be helpful if we could also amend. I know that the clients had filed a request to amend or leave so that they could file their answer to the last amended complaint. It would be helpful if I could also do that by the end of the week.
Well, let's do this. Since what I'm going to do is I'm going to adjourn this. I don't think, yes, this has been going on for a long time, but I'm going to adjourn everything, but I'm going to give you time to get to figure out exactly what you want to do. It would be nice if it were a case one could step into and just decide. I think counsel for the plaintiff is correct. I think that everybody was reported to me, got together and decided, yes, we want to kind of go along this path, and they were trying to sure things up. But in fairness, now that the Cassidys have one attorney, because I think, if I'm recalling correctly, I think throughout these proceedings, they've had separate attorneys for a number of different reasons. I'm going to give you an opportunity to do that and to clean up the pleadings. Have the two of you communicated with each other?
We just did this morning.
Okay, so extensive conversation.
So
no, that's okay. I think counsel for the plaintiff can give you certainly some background as to where it is, and then you could factor that in as to what you will do. All right. This is the second time I think we have actually technically been here on this motion, and I'd like to resolve it, but I also just want to be fair. So
I appreciate that, Your Honor.
You were going to say something else?
Yes, Your Honor, I understand, fellow counsel just arrived and his requests from his perspective are absolutely reasonable. But Your Honor, it could become exceedingly frustrating for the plaintiffs, the defendants to now be on their fourth counsel, which has led to a number of delays, late filings. And you're right, this is the second time we've been here on this motion, and we are very anxious to proceed and not continue to spend time and money while the defendants figure it out. And the prior adjournment was on December 2nd.
That's correct.
And it is now January 6th, and the new appearance from the new attorney was yesterday. There was plenty of time the Cassidys to do the things that they needed to do. I want to place an objection on the record, and if we're going to give the additional time to have that be the end of the time.
Yeah, it will be. And let me just say this, and I appreciate what you're saying in your objections noted that, but what the court is inclined to do, because we had all talked with the counsel, is do one of two things. If we could get jurisdiction over the whole case through order, then we could do that. But also, the court's understanding is I can hear the claims, award the judgment, and then somehow there's a process by which it is then certified in circuit court. So if it exceeded my jurisdiction, you just take that judgment and it's just signed off on by a circuit court judge. There's a process by which it can happen, and on a landlord-tenant matter, particularly. So that is the court's inclination. And I say that not ruling at this time, but I say that for your benefit so that you understand as you have your discussions. That's where I was going to head.
And I appreciate that, Your Honor.
Okay.
I will also note, I know that this was December 2nd. I know that there's been a statement that the Cassidys had a lot of time. I don't want to necessarily put it on the record. I'm happy to approach, and
there are issues with Miss Cassidy. Is that what you're? Yes, and I think we're all aware of that, and so I understand that. I mean, in a lot of ways, it was an odd circumstance because there were issues with an attorney who's not here today. We had to get through all of that. Then the Cassidys have 2 attorneys. That becomes an issue. And then one attorney, and I don't know the reason, I'm not saying it's bad or anything like that, for Mr. Cassidy leaves, but then another attorney appears, kind of, Mr. Lloyd. But Miss Cassidy, then that issue regarding her counsel had to be solved, and I'm not sure how that, I know what I did, but I don't know how that got resolved within the university. So a lot went on. So, and I appreciate it. I understand the time frame. I understand all of that. And this file just keeps getting bigger, and I don't have files this big. So, all right, so we'll do it. So how much, you were saying a week, are you going to be able to?
I mean, I don't want to delay this, inordinately. A week.
They're so cute when they're young. No.
Thank you.
No. I can do this tomorrow. Anyway, no, but if you have to, you can, right?
If it helps, Your Honor, I'm not able to back in work a week from today, but I could do it 2 weeks from today on the 20th.
Do I have that day?
You actually don't have.
I don't have 1 week, but I have 2.
2 weeks on 20.
Okay. Oh, no.
Yeah.
We have our one and you're not here.
Yes.
That sounds like a bad day for me, but that's okay. Well, do I have the 27th? No. I do. Okay, so that you guys don't get behind somebody that, and I have no idea.
25M600877. Antwain White, state your name, please. Antwain White. You have to start your video and unmute and state your name. Name?
Name's Antoine White.
All right. You have a hat on, sir?
Yes, sir.
You're gonna need to take that off, okay? You're charged with commercial motor vehicle, expired or improper plate, and you have the right to a lawyer. If you want one, I will give you one. Would you like a lawyer?
No, sir.
Okay, I gotta see you, sir. You're walking around. You gotta stay in one place, and I gotta have you stay there, or else I'm gonna have to have you come in, okay?
Like I said, I'm on my way to the truck now.
Why am I having you walk around, though? Why aren't you just standing there?
I just said I'm on my way to the truck to sit down.
You're charged with commercial motor vehicle, expired plate or no plate, and that is a misdemeanor, and you have the right to an attorney. I will be happy to give you an attorney if you would like one. Would you like a lawyer?
No.
I can't hear you.
No.
Okay, so you're going to waive your right to a lawyer. Here's what I'm going to do. I'm going to arraign you.
Hello?
I'm going to arraign you, and then we'll send you to the city attorney or the prosecutor. You're charged with having a commercial plate violation while you were operating a motor vehicle on I-75 near Dix in Brownstown, December 12 of 75 at 7:10 p.m. That is a misdemeanor punishable by up to 500 fines, 93 days jail, costs, or all those. Do you understand that?
Mm-hmm.
I can't hear you, sir. You got to speak. You can't argue. You can't simply say or Do you understand what I said?
Yes, sir.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. Do you want a lawyer?
No, sir.
I'm sorry, no, sir, or yes, sir? I didn't hear you at all that time. You got to talk to me, sir. Do you want a lawyer or not want a lawyer?
No, sir. Do not need a lawyer.
Okay, you sound better that time. All right. Now, this allegedly occurred December 12th of 25. Those are the possible penalties, up to 500 fines, 93 days jail, costs are all those. You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own, right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights. We're not going to have a trial of any kind. You understand that?
Yes, sir.
You still wish to waive your right to a lawyer?
Yes, sir.
I'm going to enter a not guilty plea. I'm going to give you a $100 personal bond. You don't have to post any money. Here are your bond conditions. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I will go ahead and I will set this. You stay right where you're at. We're going to put you got to be patient. We're going to put you in a breakout room with the prosecutor. You'll see if you can resolve it. Either way, you're coming back in front of me. Okay. So you'll talk to the prosecutor. Just be patient. They've got others. And then either way, you'll come back in front of me after you talk to the prosecutor. Okay. Any questions?
No.
All right. Good. You're sounding good. I don't know what happened, but sounds a lot better. Thank you. Phillips, Brittany Marie Phillips, 25B149906. Is Officer McParland here? Wait a minute, 1 second, ma'am. Yeah, you could come on up. Is Officer McParland here?
Not on Zoom.
Brittany Marie Phillips, 25B149906. All right. Good morning, ma'am. Oh, I see. You met with the department rep. Your name?
Brittany Phillips.
You're going to plead to impeding traffic. It says minor damage, no injuries. Is that what you want to do?
Yes.
All right. To the charge of impeding traffic, you plead responsible or not responsible?
Responsible.
All right. Please accepted. 195. Original charge of failure to stop assured clear distance dismissed. You go right down the hall and take care of that. You're all set. Thank you. Warnick, William John Warnick.
Yes, sir.
25F245-173.
Good morning, Your Honor.
Good morning to you. Your name?
William Warnick.
All right. You're charged with operating while texting. You got to be careful doing that. You're going to plead to impeding, right?
Yes, sir.
Right?
Well, in my defense, I was just handing the phone to my wife.
The officer said here he was watching you use your cell phone while the cars were lined up behind you.
I understand what he said, but that was not the case, sir.
Okay, you still want to plead to this?
Oh, I'll take the impeding traffic.
To that charge of impeding traffic, you plead responsible or not responsible?
Responsible, sir.
All right, I'm going to accept the plea 205, original charge dismissed, and you're all set. Yes. Have a good day. Thank you. Kenneth James McKay Jr., 25B149883.
There was no charge on that ticket. The impeding traffic.
What do you mean, no charge?
There's a one's fine on that.
205.
Okay, thank you.
Yeah, no problem.
Thank you.
Your name?
Kenneth James.
Okay, so you want to contest the violation?
Yes, Your Honor.
Okay, we'll set it for an informal hearing.
You just said.
And when are we going to do that, Lisa?
January 15th at 9.
I'm sorry.
January 15th at 9.
Okay, so January 15th, sir, at 9 a.m. will be your court date, okay? So you can go down the hall and get your notice. You don't want to take impeding, right? Okay, good enough. You're all set. Thank you. Go down the hall and they'll give you your notice. Thanks. Is Lynette Marie Johnson here? This is good. Okay. You have anything you stand there? Mr. Granata, do you have one ready?
I have one in custody, Your Honor, in Trenton Police Department, and I do have one walk-in arraignment.
Okay. Michael. Joseph Catanzaro, the third, 25 T6 47293.
All right.
Good morning to you. Your name, sir?
Michael Joseph Kaiser, third.
So you are going to plead to impeding traffic. They are going to dismiss the stop sign. True?
Yes, sir.
All right, to that charge of impeding traffic, responsible or not responsible?
Responsible.
Plea is accepted, stop signs dismissed. 150 is your total. The hall to the cashier. Happy New Year to you. Rachel Caroline Welcome. 25T647340. Good morning, counsel. How are you? Happy New Year. Your name, ma'am?
Rachel Walker.
How you doing? Are you?
Good enough.
You look scared to death. All right, so you're going to plead to impeding, right? Okay, to that charge, responsible or not responsible?
It should be in the final.
All right, I'll accept the plea. 150, cashier into the hall to your right. You're all set. Happy New Year to you. It's Jeffrey Kessler.
Yes.
Jeffrey Lawrence Kessler, 25T647-053A and B. Good morning, sir. Your name?
Jeffrey Wilson.
All right, so you have two charges. You have a obstructed vision and you also have a speeding. They are going to offer you the opportunity to plead to impeding traffic, right?
Yes.
And then they're going to dismiss the speeding and obstructed vision, true?
Yeah.
So that,
Yeah, you get them on Zoom.
to that charge, responsible or not responsible?
Responsible.
150 is your total, speeds dismissed, obstructed visions dismissed. You can go down the hall and take care of that and you're all set.
Thank you.
Happy New Year.
Happy.
What else do I have down there? Anything else? Okay. Do you have Mr. Granada's file, John? Jeffrey Axe or Ace, ACS? I'm sorry, ACS 25T647330. How are you? Your name?
Jeffrey Ace.
All right. I'm not a fan of these. You're going to plead to impeding. They're going to dismiss the operating while texting.
Yes.
The charge of impeding, responsible or not responsible?
Responsible.
Plea is accepted. Original charge dismissed. 205 is your total, okay? You go down the hall and take care of that. Good luck. Happy New Year. Hubbard, Sydney Sky Hubbard, 25B1500, not 94. Name? You're going to plead to impeding. You're going to dismiss the failure to stop for school bus. Why did you stop for a school bus? You didn't stop for a school bus? Why?
I wasn't exactly paying attention, but that's not exclusive.
No, it's really not. You run over a kid. I'm serious. This is my biggest pet peeve, this one. That and going over 105 on the expressway. To that charge of impeding, responsible or not responsible? All right, please be careful, okay? 210 is your total. I'll dismiss the original charge. Happy New Year to you. Thank you. Mark Edward Hallish, 24B724822. Why am I getting all of this? I don't get it. Does she require that they show up, Lisa?
He's on Zoom, Judge.
Oh, he is? Okay,
Yeah,
Mr.
I
Hallish.
brought him in.
Okay, Mr. Hallish, your name?
Mark Hallish.
Good morning, sir. Raise your right hand, please. Let me see it too. You solemnly swear or affirm the testimony you'll give in these proceedings be the whole truth, so help you God.
Yes, I do.
All right, so since you were in court, you were sentenced by Judge Heston, it looks like on January the 7th of last year. And since am I right? She just ordered fines, Lisa. There was no
I had a course I had to complete as well, 4-week course.
I'm checking right now.
yeah, it does say that, but I don't have any notes from the probation officer.
Yeah, looks like he had to do a DV program.
I can't figure out why they didn't send John. Okay.
Thank you for calling AM EST.
Yeah, and PM, can you walk through the hallway onto the bench here? I gotta ask you to do something for me, okay? Yes, yes.
Okay.
Thanks. I don't have Johnson here yet, right? I hate to keep calling Johnson. Mr. Pinalish, I need you to just bear with me, okay? Just take a minute, relax, and I will get back to you as soon as I possibly can, okay? Just mute yourself if you would, all right?
Yes, sir.
Jalen Gaddy, Jalen Avery Tyler Gaddy, 25 T645675C. I need the probation officer to write whether or not the defendant did everything in that one.
Good morning, Your Honor. Good morning, Your Honor.
Good morning.
P78413 with MIDC representing Mr. Gaddy. Cooper Raymond.
Good morning. Your name, sir?
Jalen Gaddy.
All right, so this is a driving on a suspended. Does he stand mute, waive formal reading?
Yes, sir.
Where in the world has he been? Fighting in the war? What's he been doing? Where you been?
I just got a new job.
No. I didn't ask you where you work, how much you're making, when you got I want to know why you weren't here 10 months ago, 8 months ago.
Oh, I wasn't aware of that I had to be here.
The officer give you the ticket?
Say that one more time?
Did the officer give you the ticket? It said appear within 10 days, right? Right?
If it did, I missed that one.
You thought the court was just going to invite you and then you didn't show up. Your address, you live on Graydale, right?
Right.
Well, we sent notices there. You don't read your mail?
That's my.
Well, then just be honest with me and tell me, Judge, I blew you guys off for 9 months. I thought I was larger than life. Don't start standing there lying to me that you didn't know you were supposed to be here, okay? I hate that. Listen, don't interrupt me. Don't interrupt me. Okay, we're not sending out parties invitations here. You know what I'm saying? We didn't invite you to a party. You don't have to go to a party. You don't have to do anything, but you do have to show up in court or there are consequences. We understand one another? Where does he work?
Your Honor, he's working at a florist right now. He's been there for a couple of months. Prior to that, he was at a logistics company, had been there for a couple of years.
You got $100 with you?
Yes.
$100 cash bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. Let me let you in on another secret. You are not going to endear yourself to these judges in these other courts when you blow them off too. You got 3 out of 36, 2 out of 35th. You got 5 other warrants. Okay? Unless you're hell bent on going to jail, in which case you keep doing what you're doing, you're going to end up there. I'd go over to those courts and I would surrender today, not tomorrow, today. Do you understand me?
Yes.
Good. Give me a pretrial date if you would, Lisa, please.
I think we put it on the front.
Okay, I'm sorry, you did. January 15th at 10. So without,
I believe we had a conflict on that date. Can we do the 21st? I'm here back on the 21st.
Who has a conflict?
My client,
What kind of conflict does he have?
I believe it's work related.
What kind of conflict you got?
You have to work that day in 15? Correct.
You show up 8 months later and you want me to make accommodations for you. Who's this with you? Is this girl with you? I could tell she knows what I'm talking about. She thinks you. What, you got to work, so you want me to reschedule it?
If you may.
I can't do it on the 20. Do we have the 21st when we can do it, Lisa? We don't have the 21st, do we? This is Trenton.
No, it would be the 29th.
Still work it out. We'll do the.
I can do the 29th for you. I'll be more fair with you than you have been with us. How's that? You want me to do the 29th or the 15th? It's up to you. But Trenton's only here on Thursdays.
I have a conflict, Your Honor, on the 29th. We have to do it.
Okay, 15th at 9 a.m. You're gonna have to
Judge.
fill out the, what?
Did Mr. Granada say he has a conflict?
Yeah, I don't know what.
He's just the arraignment attorney. He doesn't follow these cases.
Oh, yeah, you're just, I thought so. So you don't have to worry about that. Do you want to do the 15th or the 29th? Are you sure? 15th at 9, go down the hall, post your bond. Don't be doing this again. I'm telling you, I'd go over to those other courts. Those warrants have been outstanding for quite a while. We understand? Yes?
Are you saying I have warrants now?
5 of them. Yeah. Why do you think I'm talking to you like this? Plus, you blew us off for 8 months. Stop and don't come back with chewing gum either. Okay? We're not in a candy shop. Go down the hall, get your notice. Good luck. And you're going to have to fill out a petition for a court-appointed lawyer if that's what you want going forward. All right?
Yes.
Good luck. Armin Lewis Gordon Jr., 25W841052. Is she here? Do you know if Mr. Gordon is here, Lisa?
Not on Zoom.
I'm gonna need Lieutenant Toller in here. Is there a Gordon in here? Armin Gordon Jr.? I'm gonna need him in here. And I don't know what I'm raining Trenton. What do you have in Trenton there? Boy, this is a mess today. What do you
Video for
guys-
Jack Young.
That's my case, Your Honor.
Who is it?
Jack Young.
Jack Lee Young.
People against Jack Lee Young, 192-634-292A.
Morning, Your Honor. Peter Granada, P78413 with MIDC representing Mr. Young for our meeting.
Sir, your name?
Jack Young III.
Detective, your name?
Detective Corporal Shawsh Pontiac, Trenton Police Department.
So I've got contempt charges here. I hope, Mr. Young, can I ask you a question? How old are you?
I'll be 45, Your Honor. Well, I'm 45. 45.
Why would you do this? Why would you act like a fugitive on a drivewall suspend charge?
Your Honor, he was incarcerated.
For how long?
Most of 2024 and most of 2025.
Well, he was supposed to be here in 21 and starting to take care of this in March of 21, so that's not an excuse. He should have taken care of it in 21. If somehow, some way he was in the hospital for 10 months, he could have come in and taken care of it in 22. If somehow, some way, something tragic happened in 22, he should have been here in 23. You got a big problem with me. And by the way, you can tell, well, I just don't understand this. Warrants all over the place on this guy. I don't even know what I have here. It's going to take me a minute to decipher this. I got all kinds of files in here. I got two, I don't even know what in the world. I got
It looks
two,
like they're
3B
both for non-payment.
I got 23B143198. It looks like on that case, he owes 129. And on the other one, on the misdemeanor,
He owes 644 on that one.
he owes 644. All right, so how's he going to proceed on these?
Your Honor, I believe that he's prepared to make a payment today.
Well, I know, but is he going to plead guilty to failure to pay 644? And is he going to plead guilty to failure to pay 129? Or does he want to have a contested hearing?
No, there is no contest. No.
If you plead guilty to failure to pay 644, you could get 93 days. Do you understand that?
Yes, sir.
Talk to me. If you plead guilty
Yes,
to
sir.
failure to pay $129, you could get 13 days on that, 1 day for every $10 owed. Do you understand that?
Yes, sir, Your Honor.
You have the right to a contested hearing. At that hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. You remain silent, that silence would not be held against you. Do you understand that?
I do, Your Honor.
If you plead
Yes, sir.
guilty, you're giving up all those rights. We're not going to have a hearing, and I will then sentence you on these charges. Do you understand that?
Yes, sir, Your Honor. Is it okay if I talk to my lawyer again about this, Your Honor?
We want to wear the 664, 644.
Well, he's got a big problem. He sees this happening. I'll let you talk to your lawyer again.
I think we want to try to work out something that he could be released today. And
I'm not going to release him. This guy's been playing with us for 4 years. I don't know who he thinks he is.
we could try to work.
Your Honor, I've been taking care of my life, Your Honor. I've been on drug court for almost a year.
Listen, talk to the
Yes,
guy
sir.
in the carnival if you want. I don't want to hear it.
Yes, sir,
You
Your
got
Honor.
warrants all over. You are disrespectful. You have no respect for the system. You think you can just treat the system like some pet of yours, and it's not a pet of yours. We're not a pet of yours. So shake your head all you want. I can only go by what I see. And what I see is warrants that have been going back and forth since 21, and you've been given plenty of chances. So don't talk to me about releasing you today. It's not happening unless you have the money to pay this. I'm telling you. So you guys can talk again, and we'll go from there.
Okay.
You be brief, Your Honor.
Yeah, no problem. Take your time.
Thank you.
Do I have Armin Gordon Jr.? John, you need to call Toller. I don't know where he is. I need Gordon on that one.
Toller on what one?
Armin Gordon Jr. It looks like Toller wrote it, and and Gordon, it must have been here, but he left or what have you. Is Lynette Johnson here yet?
Yeah.
Come on up here, Lynette Marie Johnson. 25B82374. Ma'am, your name?
Lynette Johnson?
You posted a bond to 213. Was that in your name?
Yes.
I can just apply the bond. Why did you ignore us?
I honestly have nothing. I
Okay.
can't come up with anything good except for one day turns into another very quick.
Yeah, tell me about it. Lisa, does she owe $213? I don't see the bond. Is it in her name?
Let me check.
The
It's in the third party, Carol Johnson, and her balance is 248.
You owe 248.
Thank you.
You're gonna get Carol Johnson to come over here and sign over the bond? Otherwise, I have to go through the process.
I mean, my mom's disabled.
Okay,
She needs the officer permission.
hang on a second. Slow down.
Did she check that box, Judge, on the form?
See, I don't, oh, here it is. No, all I got is third-party poster posted by Carol Johnson. You're right.
If she wants to call in, we can do it over the phone.
You want to call your mother?
Yeah.
Call your mother out in the hallway, and then I will recall, if she's gonna apply the bond, come on back in. Either way, come on back in and we'll take care of it,
How
okay?
about just the 213, right?
Yes,
Okay.
Yeah.
Actually put a payment for the rest.
I'll worry about that when we cross, I'll cross that bridge when we
So
get to.
I call her and bring her phone into here.
No, you can just have her call. Go down the hall.
Yeah.
Listen, just listen, please don't go anywhere. Go down the hall and talk to them and they'll tell you how to do it, okay? You're gonna call your mom and then you can put her on the phone, on your phone with somebody in the criminal department, since you're telling us she's disabled.
Yeah.
And she can give the go-ahead if that's what she wants to do.
Thank you.
Thank you.
Lieutenant, sir.
Lieutenant Toller, do you have any idea where Armand Gordon Jr. is? Looks like you worked this out, improper parking.
See them. See it here. I told, but
Morgan, Peter Leon Dundee Morgan, 25F 731-065. Who do I have here? Is Mr. Leon Dundee Becker here or Reader here? I don't know.
sir, you gotta take your hat off.
Peter Morgan, you can tell me your name.
Peter Leon Dundee Morgan.
Who's Leon Dundee Redder?
No idea,
For the-
sir.
For the attorney, I have Miss Fanning.
Okay, somebody wrote
Listen.
Leon Dundee Redder on here. Okay, as the court appointed, I thought that was a little strange. Yeah, Ms. Fanning, your appearance? Ms. Fanning? All right.
Mr. Gordon's in for me.
Mr. Gordon, what are you doing? Armand Gordon Jr., come on up here, wherever you are. 25W8411052. I've called your name about 5 times. Okay, come on up here and state your name. Your name?
Gordon.
You're going to plead the improper parking? I thought you met with the department rep and said you were going to plead the improper parking. Is that true or false?
He was saying come to a compromise, but didn't tell me specifics.
Keep your voice up.
He didn't tell me any specifics, just told me he would come to a compromise.
He's saying improper parking as opposed to handicap parking.
Yeah. It's because it was originally a handicap parking.
Did you park in a handicap parking zone?
Yeah, for a time period, because I was moving on my bus.
You want to plead do you want to plead to improper parking, or do you want to have a hearing on handicap park?
I just give it up.
To that charge, improper parking, responsible and not responsible. You can't park in the handicap zone.
I know that, sir.
I don't like those. You know what? School buses and parking in handicap zones are my top 2.
My only reason I'm very lonely was because my girl was trying to carry stuff to the car, so we can move that. Like, we literally left 5 minutes after we got that ticket.
You can't park in the handicap zone. Okay? $100. I'll dismiss the handicapped. Please don't do that again, okay? Thank you. Have a good day. $100 down the hall. Mark Edward Hallish.
Yes, sir.
4B724-823. Sorry to keep you waiting there. Or
No
822 rather. Your name again?
Mark Hallish.
Raise your right hand. You solemnly swear affirm the penalties of perjury, the testimony you've given these proceedings will be the whole truth, so help you God.
Yes, I do.
All right, so this was taken under 7694A. I believe, right, Jenna? Oh, right. Didn't look. Judge Hesselby uses a different form than I do, and I don't see. Yes, she did write it down here. Okay. Since you were in court on January 7th of 25, have you been arrested?
No,
Any new charges?
no,
Any contact with the police?
no.
Congratulations. Your case is dismissed. I wish you well. Good luck to you.
Thank you, sir.
Have a good day.
You too.
Ms. Fanning, if you're ready, pop your head in. I'll call your case. I called it once. If you're ready, I'll do it.
Judge, she asked for,
But I
she
did
asked for a
ask for a breakout room first.
Okay,
If I can.
Gabrielle Christine Popovsky, 25W838818A. Good morning.
Good morning, Robert Gill with Hicksville, Mr. Posky, this is Mr. Stino's matter.
Casino 253, Jen. All right. Your name, ma'am?
Gabrielle Pulaski.
All right, so she has a charge here of failure to refrain from consuming alcohol, being arrested on September 4 of 25. What is she going to do?
Judge, I think the violation was picking up a new effect.
It is.
She pled guilty to 2 other counts the last time we were here. We put this one on hold. She still hasn't been charged on that case, although the time standard against casinos, the blood draw is met. So what I'm hoping to do is to adjourn this one more time.
She pled guilty to 2 other counts?
Yes. And she was sentenced to IOP. The adjustment may be sober.
I'm lost. Your name?
Lisa Tito. You sentenced her on first 2 counts, but.
Wait a minute. I only have one blue bag here. And that's the failure to refrain from consuming alcohol, being arrested for OUIL on September 24, 25. That's the only one I have. I don't know why this is happening more and more lately. I just don't understand why this is happening. Can you fix this for me, please? Get the other blue back, and then I'll recall the case, if you will, please. Thanks. All right, I'll call you again there, counsel. Which one do you have?
I have Jacob Massick, Judge.
Jacob?
That's why you sentenced her on the other ones. You were only dealing with the count 1.
Oh, he said, I thought you said you pled. Okay, let me come back to that. Jacob Kelly Massich, 23T640501.
Good morning, Judge. John Graziani, P number 43387. Mr. Massick, you stood my left to take him. Please identify yourself. I'm Jacob Massick.
All right, so we have a charge of failure to attend the probation visit on December 12th. And we have a charge of failure to pay all fines and costs as ordered. And we have a charge of failure to clear all warrants by November 7th.
Judge, he has taken care of all that. This is just as a matter. He paid him $415. They will pull them out.
All right, but he didn't do it when he's supposed to, right? So I'm going to need either a plea or we're going to have a hearing on these.
365.
Charges failure to pay your fines and costs is ordered. I don't know how much he owes. They just think you didn't pay when you were supposed to pay. So I don't want to know about it. We're either going to have a hearing or you're going to plead guilty. One of the 3 things. One of the 2 things, I should say.
Guilty, Judge.
On all 3 counts?
Yep.
All right, if you plead guilty, these would be 3 technical violations. And you could get, as a matter of these, as per law, pursuant to law, you could get 15 days. I'm just telling you that's the max. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you will be giving up, Jessica, all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
To the charge failure to schedule your probation visit on December 12th of 25, how do you plead?
Failure to schedule it or?
Failure to attend, I'm sorry, failure to attend your appointment on December 12th.
Judge, I will have an explanation for all this.
That's fine. Did you fail to attend your appointment on that date?
Yes, sir.
The charge 2, that you failed to pay your fines and costs as ordered, how do you plead?
Guilty.
Did you fail to pay your fines and costs as ordered?
Guilty.
Did you fail to pay your fines and costs as ordered?
Yeah.
Did you fail, charge count 3, that you failed to clear your warrants by November 7th? How do you plead?
Guilty.
You failed to clear your warrants by November 7th.
Yes.
Anybody force you to plead guilty? All right, I'll accept your plea to all 3 counts. What's the problem here? What?
With regard to the probation visit, there was a misunderstanding. He in fact had contacted Jessica within an hour and a half on that date. And it's my understanding that they in fact rescheduled this matter. It's a very serious matter because it's under highness. So Mr. Masick certainly doesn't want to have this on the record for a while. Secondly, he's taken steps to make payments, and he tends to make another $100 payment within the next week and a half. And then
Okay, he was supposed to pay 40 per week beginning October 27th after paying $270 on the date of the sentence.
This one.
I'm sorry?
he understands that, Judge.
Why didn't you come and talk to me if you couldn't make the payment like I told you to?
When I spoke with Jessica on the phone, I told her I was having trouble finding a job, and she told me that she would give me a little bit longer to make the payments. She sent me staffing agencies to obtain a job. And I explained to her that I was having issues clearing the warrant and making the payments. And she told me that on the 12th, we would talk about an extension. I missed the phone call, so we didn't get to conversate about it. I called her at like 9:30, 10 o'clock, and she didn't answer, and I got the from her about the violation.
Why didn't you clear your warrants by November 7th?
I just didn't have the funds to clear it.
Judge, I'm currently working at Watson Engineering, and
What does he do there?
I'm a laser parts puller.
I'm not very, well, you should have called me.
I'm sorry.
Are you on this one, Ms. Reynolds?
Miss O'Donnell's out of the office.
Oh, okay. What do you, your appearance?
Elizabeth Wasserich, Your Honor.
What can you tell me about this? He's just pled guilty to all 3 counts.
Yes, Your Honor. In regards to the probation visit, Ms. O'Donnell met with Mr. Masich at the end of October, and that was a scheduled visit. She emailed him after meeting him with via Zoom for that scheduled appointment. She doesn't have listed a file any follow-up, but I think it is at that point in time that she ran a record, realized that the warrants at that time were cleared or warrant, I should say. Looks like he had an outstanding one at the time at 34th District. In regards to the money, he did not pay as ordered. He made one payment on his fines and costs after the show cause was issued. I believe it was $50. I just looked at it. He did not pay at the rate that you ordered him to pay, which was $40 per week, beginning October 27th. His bond was applied, and again, he's only made one payment, which was after the violation. I don't, in regards to work program, it looks like everything's completed with work program. There's no update in regards to his anger management program. It does not appear that he's registered or completed that program.
I don't know why you didn't just call me.
I should have came and seen you. I contacted her and spoke with her about the warrant. She told me that on the 12th when we talked, she could give me a little bit more leeway to clear the warrant, and I came out to her. I'm sorry, Your Honor.
I'm accepting the pleas. I'm gonna listen to whatever else you have to say, and then I'm gonna send. Anything else?
It won't happen.
I was talking to your lawyer first.
Judge, please take into consideration that this man provides a significant amount of support for his family, his wife and 3 children. He recently got his job at Watson Engineering. He's not a bum, and that's how we.
What'd you say?
He's not a bum.
Nobody said he was a bum.
Jeez. I was worried about the implied.
Anything?
I'm just sorry, Your Honor. It won't happen again. I got a stable job now. I'll be able to make the payments and get everything taken care of at a decent time.
Serve 8 hours of community service by January 31. I'll keep you on probation. I won't assess any additional fines. You're to clear all your warrants by January 31 as well.
All the warrants are clear, sir.
Okay, well, good. Then we don't have to worry about that. All you have to do is your 8 hours of community service by then, okay?
Thank you so much.
Thank you very much. Good luck to you, sir.
Thank you, Judge.
You need to talk with him for any reason? Joe Brannon. Joe Ursi Brannon, 25T647343. And we are on which one? What did you have again?
Gabriella.
Your name, sir?
Joe Brandon,
You're gonna plead to impeding traffic, right? Responsible or not responsible for that?
responsible.
Plea is accepted. $150. You can go right down the end of the hall and make that payment, okay?
Thank you.
Happy New Year to you. Which one?
That's the one. You.
Popovsky?
Yeah.
Gabrielle Christine Popovsky, 25W83818A. All right, so maybe I misunderstood Mr.
It is confusing because I included.
Your parents, Mr. Haynes. Okay, your name?
Gabrielle Kowski.
Get that phone out of here.
I here,
Gotta go.
Oh,
what do I do with that?
Put it in your car.
I don't have a car.
ma'am, just stay right there. Shut the
I'll turn it off.
phone. Please. Thank you.
Emily Casino. I was just gonna say, it is confusing. We dealt with the show cause, back in October where I included that she was arrested for the offense. You had me issue it for a separate show cause for the new offense, but she has still not been charged.
What was the show cause I have of October 27th is for being arrested for OUIL.
Correct. You had me issue its own show cause and we adjourned it to today to see the outcome. I ran her record and she still hasn't been formally charged, but I was able to obtain the blood draw results. So I don't really know how you want to proceed.
Okay, but what I've got is she was found guilty on October 27th. Hang on. Up there to submit the chemical testing October 14th. Count one was dismissed on motion of the probation officer. So then I took that, it looks like, and ordered additional costs of $100, attend outpatient treatment or IOP as determined by the therapist, serve a day on the court work, and pay $35 for that. And then to remain on a sober link and test once a week. So all I've got outstanding then is this charge, and she's not been charged, right?
She is not charged, but I do have the blood draw results. So I don't know if you want.
For the results.
0.333.
Why what they're waiting for? What department is this?
It's Van Buren. I called over there today and yeah, they were able to provide me the blood draw results. It looks like they've had them since October 15th, but I looked it up. There's no court date scheduled and it doesn't even show up on her criminal history. It just has the permit on her driving record, no charge either.
Okay, so but do you have the show cause of October 17th?
So I have a.
Let me see that. That's the problem. I didn't have that one. All right. Why did I write down not guilty plea as to count 3? I can't figure this out. There is no count 3. Or unless I assumed that, look, she should be charged with failure to refrain from consuming alcohol. on the offense date.
Yeah, that's what I did. No, I literally just got the blood draw results today, so.
I understand.
I-
So that's what I'm doing. She's gonna she's gonna type up a new charge of failure to refrain from consuming alcohol. And I'm gonna have a hearing and I can rely on hearsay for her to establish that she consumed alcohol.
We haven't even had a chance to discuss how she's pleading.
No. I'm not suggesting we move right now. She's gonna do the new one. And you're going to talk to the defendant and see how you wish to proceed, okay? And I don't care how long it takes us today. I'm gonna hand you these back. I think count 3.
It's weird because I think it's technically count 1 because it's considered technical, not a non, you know. What I mean?
Yeah.
So I think we might have just added.
It's a non-technical instead of a technical. I get it.
Yeah.
All right, so just bear with us and we'll be back with you, okay? Thank you. Richard Wansowitz, 25T647351. Your name, sir?
Richard Savage.
All right, so you had problems years ago, but you've corrected them, right? You're gonna plead the impeding, right?
Correct, Your Honor.
Responsible or not responsible for that?
Responsible.
All right, please accept at 175. You can go down the hall and make your payment and you're all set. Have a good New Year.
Happy New Year. Thank
Same to
you.
you.
Thank you.
All right, let's take Antoine White, 25M600877. All right, Mr. White, tell me your name, please. Good morning. Your name again, sir? You're muted. There you go.
White.
All right, so you maybe you should have gone to law school. You got yourself a good deal here. Compliance with law. What does she mean by that? Do you know?
Our tax and everything was done. We spoke to the officer. He did say he didn't want to pursue it. That's what he said. Just wanted us to get it taken care of. We got it taken care of the next day. It's out to 27.
Good enough. Case dismissed. You're all set. Happy New Year to you. Good luck.
Same to you as well.
Thank you. All right. Do I have Ms. Fanning out there? Peter Leon Dundee Morgan, 25F7311065. All right. Good morning again, Mr. Morgan. Your name?
Your Honor, if it pleases the court, Attorney Andrea Fanning, P42853, appearing with my client, Mr. Morgan. If he's not here, he's stuck in that breakout room.
He's right there. Your name, sir? Your name?
Yes, I can hear.
Mr. Morgan, I need your name, sir.
Peter Morgan.
All right, so what do you want to do here? What are you doing? This is going to be an adjournment so you can review discovery, right?
That is correct, Your Honor. So we're prepared to waive whatever timeframes. I did discuss with Mr. Morgan that I was recently appointed, that we need to go over the discovery so that we can make a decision as to whether or not we're going to waive or hold the preliminary exam. So we're asking just to come back in a week for PCC.
Mr. Morgan, do you understand what your lawyer's saying? You have the right to a probable cause conference within 14 days of the date of the arraignment. She was just appointed. She needs more time to prepare. If I grant her request for an adjournment, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, Your Honor.
Do you waive that right?
Yes, sir.
Anybody force you to do that?
No, sir.
All right, I'll accept the waiver. We'll adjourn it to January 13th, and January the 20th will be the exam, okay? You're going to be in front of Judge Hessen going forward on these, or is this mine still, Lisa? I don't know.
No, it's Judge Hessen's.
Okay. When are we doing January 13th? Will be at what time?
10:15.
At 10:15 on the 13th, and then the 20th will be at
11:30.
at 11:30, okay?
Thank you so much, Your Honor. Thank you.
Have a great Happy New Year to you, Ms. Fanning.
Same to you. Thank you so much. Bye-bye
Take
now.
care. Good luck,
Bye-bye.
Mr. Morgan. Thank you.
Thank you. Bye-bye.
Thank you, Your Honor. Thank you, Your Honor.
Do I have Steen in here?
Your Honor, this is Alexandria Taylor on Steen.
Oh, Markelo, Keith Steen, 23B726626. Good morning, Ms. Taylor. I've not seen you. Where are you at there? How are you?
It's been a while, Judge. It's so good to see you. So I'm still on my own. I'm downtown Detroit, and I'm still teaching at UDM Law.
Good. Well, it's nice to see you. It's been quite a while. I've been wondering how you're doing.
Happy New Year.
Same to you. So your client, Markelo, where's that?
Yes, Alexandria Taylor appearing on behalf of Markelo Steen. Mr. Steen, can you unmute, turn your camera on and state your name for the record? I see him on here.
Yeah, he's on there. Mr. Steen, you have to start your video and unmute.
Is it on my phone now?
Yeah, there you go. Your name?
Markelo Steen.
All right, so you want to adjourn the PCC for 2 weeks and the exam for 3 weeks, right?
That's correct, Your Honor. I had a chance to speak with Madam Prosecutor, and she doesn't have the video discovery yet. And so she sent another email, and hopefully we'll have that by that date, Your Honor.
Okay, so sir, do you understand what your lawyer is asking me to do? She wants an adjournment. She needs an adjournment so she can prepare. You have the right to a probable cause conference within 14 days of the date of the arraignment. She needs time to prepare. She's asking for 2 weeks. I'm willing to grant that. If I grant that request, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, sir.
Do you waive that right?
Yes, Miss Taylor has my full confidence. Yes, sir.
Anybody force you to do that?
No, sir.
All right, I'll accept the waiver of the 14-day rule. We'll set it for January 20th, the PCC, and that'll be at what time, Lisa?
9:15.
And you're going to be in front of Judge Hudson on that, right?
Yes, Your Honor.
Or not?
No, it's Judge Hudson.
Okay. And then the 27th is going to be at what time?
11 o'clock.
At 11 a.m. So 9:15 on the 20th and 11 a.m. on the 27th. It's so good to see you, Ms. Taylor. I've been wondering how you're doing.
So good to see you, Judge.
If you get over here in person in front of Judge Hudson and you don't see me on the bench, stop in and say hi, okay?
I definitely will.
All right, take care of yourself.
Take
Good luck,
care.
sir. Thank you.
Thank you.
Jordan Berry, 25T647283. And then I don't even remember who this gentleman is there, Mr.
It's Mr. Young on Zoom.
Yeah.
On video.
Right. Okay.
Also,
Jordan Berry here.
Lynette Johnson with the bond issue. She should be back in the courtroom.
Okay. Jeez. I got files all over the place here. Wait a minute. Where's Jordan Berry at? Is Jordan Berry here?
Yeah, I'm here. I'm on Zoom.
On Zoom.
I don't see him. There you are. 25T647283. Your name?
Jordan Berry.
All right, you're going to plead to impeding traffic, right?
Yeah, it was either
And
that
they're
or
going
a
to
parking
dismiss
ticket.
this. They're going to dismiss the amber, right?
Yeah,
To the charge of impeding traffic, responsible or not responsible?
responsible.
Is accepted. Original charge dismissed, $150. You can go on 33court.com and make your payment. Okay.
Okay, awesome. Thank you.
Thank you. Happy New Year. Jack
Happy
Lee Young III, 23B143198. And I need to find the other file. And I have 19T6342928. Mr. Young, your name?
Jack Young, III, Your Honor.
Your Honor, I spoke to my colleague.
I need your appearance.
Oh, I'm sorry. Peter Granada, P78413, MIDC counsel for Mr. Young. Your Honor, I spoke to Mr. Young and he understands and is going to plead guilty to both counts.
So if you plead guilty on the civil infraction, that's 3198. You could get 13 days. You can satisfy that in full by payment, in full by serving a jail term, or in part by payment and in part by serving the jail term. Do you understand that?
I do, Your Honor.
And again, if you plead on the failure to pay 644 on the misdemeanor, you could get 93 days. Do you understand that?
Yes, sir, Your Honor.
And you understand the rights that I covered. You're presumed innocent. You have the right to a hearing. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial of any kind. Do you understand that? Do you understand that? I can't hear
Yes,
you.
sir, Your Honor.
All right.
I'm sorry. Yes, sir, Your Honor.
Is a civil infraction charge, failure to pay on that one, $129. How do you plead?
Guilty, Your Honor.
Did you fail to pay on that?
I did, Your Honor.
Anybody force you to plead guilty?
No, sir, Your Honor.
On the misdemeanor charge where I sentenced you back in 21 on a 2019 case, to that failure to pay $644, which has just been late fees and default fees and warrant fees and the like. How do you plead to that?
I plead guilty, Your Honor.
Did you fail to pay on that file?
Yes, sir, I did, Your Honor.
Anybody force you to plead guilty to either one of these counts?
No, sir.
Pleas are accepted. I find the pleas have been made voluntarily and understandingly and are accurate. I don't know what happened with the Lynette Berry's file. Would you make sure it's not down there, John? I don't know. I don't know what to say. The counsel, I mean, he's given me no choice. I have no choice here unless I'm prepared to just let somebody do this for the next 22 years. He's been blowing us off left and right.
Your Honor, he understands that he's going to be in custody until he comes up with the amount. He says he should have the amount within the next few days, at the most a week. And so he's going to go to friends and families and try to collect it all up so that he can get released. And then anytime he's served between now and then, be credited against that.
When was he taken into custody, Detective? Can you tell me?
I believe it was just this morning.
Why do you do this? I mean, are you in the habit of doing this? Let me check you have to be. You haven't just pointed out the 30.
Yeah.
Hang on.
I got my.
Hang on. Let me just check.
Yes, sir, I apologize.
You haven't been just singling us out to thumb your nose at. You've got other warrants. Your criminal history is thick. I mean, you've been getting, when you going to grow up? I mean, you've been getting in trouble since you were in 2001 and you are 44 or 5 now.
You're right. Yes, sir, Your Honor.
So this has just been a consistent pattern of you just disregarding laws. And
I had an awakening up last year when I went to jail for a year. I've been trying to get my life together, Your Honor. I haven't been in no more trouble since then. I've turned my life around to God, and I've just been trying to make sure. I've been trying to right my wrongs, Your Honor, and it's just been so hard to do all. It's easy to get into this, and it's been very hard to change, and it's just been a slow process, Your Honor. But I am striving to be a great person and not be disrespectful.
Your Honor, I would like to add that after Young is released, I'm going to work with him to get his iChat so he understands where his warrants are, so we can try to get all of those resolved.
Lisa, you remember that language I gave you a long time ago? I haven't done that, used that in a while. Defendant to be given $10 credit for each day served.
Yes, I think I still have that somewhere.
Hey, your record's bad.
I do have it, Judge. You want me to read it to you?
Yeah.
If each day served shall reduce the cost by $30, any payments made by defendant shall further reduce the time required to be served by 1 day for each 30.
Okay, so it's actually on these civil infractions, it should be 10, I believe. So we're gonna make that $10 instead of 30, okay?
Okay.
So that's what I'm gonna sentence you to. You pay 129 or serve 13 days, you're to be given $10 credit for each day served. So if you served 5 days and you only owed 79 and you paid that, you'd be released in terms of this file. Do you understand that?
Yes, sir, Your Honor.
Now, the other case, I mean, look, I feel bad about this, but you've given me no choice. You really have. You were told by Judge Hessen to pay $200 a month back in December of 21, and you kept coming in custody and everybody was giving you breaks.
I went to jail, Your Honor.
You pay $640. That, listen, I heard what your lawyer said. Were you in jail in 21?
Not in 21. No, sir. Your Honor. No.
All right. So what does you being in jail in 24 and part of 23 have to do with the fact that you didn't do what you were supposed to do in 21?
I apologize, Your Honor. I should have listened. I apologize. I totally apologize. I'm sorry.
On this case, I'm going to take into account any credit for credit that you might have had for these other arrests, and I'm going to reduce this all the way to 25 days. So you're either going to pay $645 or serve 25 days on that one. So if somehow, some way, you can come up with 760. Let's see, that was 129, $773. You're going to be released immediately. Okay. If you don't, then you're going to have to serve the 25 days. Lisa, those are running concurrent. Okay. They will run concurrent. So they're not going to run consecutive. They will run concurrent. I really hope you grow up and change your life. This is kind of distressing to see as an outsider what you're doing to yourself. I mean, they only give us one of these things.
You've seen my whole life and my family, Mr. McNally, and I apologize to you, and I'm turning around. I promise you won't see me again.
I wish you well. I wish you well. I really do. Good luck.
I appreciate that.
Thank you. Patricia Ann Mosier. 25T647-210 A and B. Is Patricia Moser out there somewhere?
Yes, I'm here.
It's on Zoom.
Oh, Mosner, I'm sorry. How are you? Your
I'm
name,
good. How
ma'am?
are you? Patricia Masner. Looks like Mosner.
Yeah, you have to start your video for me,
Oh,
okay?
sorry. Okay.
No problem.
And there it is.
That's all right. Take your time. I'm just give me 1 second here, okay?
Okay. Thank you.
All right, so you have 2 files. There was an accident, and they're going to dismiss there to stop assured clear distance.
Yes.
And you're going to plead to impeding traffic. There was minor damage, no injuries, no vehicles towed, and then you're going to plead to no proof of registration.
Correct.
With the understanding that the expired plate will be dismissed. True?
Correct.
All right. So to the charge, impeding traffic, you plead responsible or not responsible?
Responsible.
And to the charge of no proof of registration, responsible or not responsible?
Responsible.
All right. I'm going to accept those pleas. I'm going to dismiss the expired plate and fair to stop assured clear distance. On file A, that's the fair to stop that you pled to impeding, 195. On file B, the charge that you pled to no proof of registration will be 100. That's 295. You can either bring the money up here or you can go right online, 33court.com, and make your payment. Okay.
Okay. And do I use the court case from today to do that so that they can find me, or do I use the original ticket?
The ticket.
The ticket. Okay. Thank you very much.
You're going to pay on the fair to stop. That's file A, 210A, and the other one, which is impeding now. And then the other one, no proof of registration, is 210B. Those are the last numbers. Okay.
Okay.
Happy
Thank
New
you
Year.
very much.
Thank
Happy New
you.
Year. Bye.
Talk to Mrs. Young by chance?
Judge, I don't have her number on me. I left.
Oh, that is until one. I'm sorry. Nicholas Abanizio, 25T647-285. Your name?
What's happening, zero?
You're going to plead to impeding, right?
Yes,
Responsible or not responsible to that?
responsible.
All right, $165 is your total, okay? You can go right down the hall and make your payment. Good luck. Thank you. Gavin Canal, 25M632019B. Gavin Canal here?
Yeah.
He's on Zoom.
Let me check something here. I don't think they wrote up anything on this one. Oh, maybe it's.
It's
in
an
the-
informal with a state police officer.
Oh, I'm sorry. Okay. All right. People against Gavin Ellis Canal, 25 M632019A and B. All right, Trooper, your name?
Yep. Good morning, Your Honor. Daniel McLaughlin.
Mr. Canal, your name?
Oh, Gavin Canal.
So he's charged with limited access, 88 and a 70. You wrote him for 75 and a 70. And then he has a seatbelt violation. Any other offer on this?
Your Honor, I don't have his driving record in front of me. Does he meet the requirements of the court for a reduction by chance?
Let me see. I don't have it either.
Okay, I apologize. I'm in a meeting, so I wanted to make sure I got the court before I missed it.
He has a no proof of insurance from January of 25. He had a hazardous action charge, crash, failure to yield, but it looks like he wasn't convicted of that in 24. So he probably got impeding or something back then. So he would qualify if you want to give him whatever else or whatever you want to do.
Yep, I'll work with him. I'll give him impeding traffic for the speed, but the seatbelt violations can remain as is.
So do you understand that? You want to plead to impeding traffic, sir?
No, sir.
You don't want to plead to impeding traffic? It's 0 points. It won't go on your record.
All right, I'll do that.
Okay. All right. You don't have to do that. Nobody wants you to. No, we're not trying to force you. If you want to go to hearing on 75 and a 70, you can do that.
Oh, no. I don't want to do that.
All right. So you want to plead to impeding and seatbelt?
Yes, sir.
To the charge of seatbelt violation, responsible or not responsible? Responsible or not responsible, sir, to seatbelt? Are you listening to me? Can you hear me?
Yeah, no, I can hear you. I didn't know if you were talking to me or him. I'm sorry. This is my first time doing this.
So I'm talking to you, to the charge seatbelt violation, responsible or not responsible?
Responsible.
To the charge impeding traffic, responsible or not responsible?
Responsible.
165 on the impeding, 65 on the seatbelt, 230 is your total. You can come in and pay that today, or you can go online, 33court.com with your case numbers and pay that. It's up to you, okay?
Okay, does that got to be paid today?
When can you pay it if you can't pay it today?
Friday. But
Okay,
I can do it today. I can come in and
I'll just give you till the 12th, which is Monday. If you can pay it today, great. If you can't, just make sure you pay it by Monday, okay?
Okay, thank you so much.
Do you have any? Have a good day. Happy New Year. Trooper, do you have any more?
Yes, sir. I should have another one for Mr. Marshall.
Darwin Edward Marshall Jr., 25M626089. Is Mr. Marshall here? Come on up. All right, so he's charged with limited access, 86 and a 70. You wrote him for 75 and a 70. Do you have his traffic record?
I don't, Your Honor. Like I said, I'm inside of a building in a meeting. I don't have my computer in front of me. I do apologize.
That's all right. So in 19, he had a no proof insurance. In 19, he had a disobey stop sign. In 16, he has no proof of insurance. I mean, if you want to, he's got other no proof insurance back in 16, a limited access or a speeding charge in 2010, but he qualifies for impeding if you'd like to offer that.
Absolutely.
Do you want to plead to impeding?
Yes, sir.
Your name, sir? All right. To that charge of impeding traffic, responsible or not responsible? All right. Be a little careful now, okay? 170 is your total. You can go down the hall and take care of that. And you're all set. Just slow down, all right? Best of luck. Happy New Year. No, is that it?
I believe so, Your Honor.
Happy New Year to you. Take care of yourself. See you soon.
You as well. See you soon.
Melvin McGee Jr., 25W 840861. A and B, defendant failed to appear, is responsible, is charged by default. You're here?
Yes.
Are you Melvin McGee? They wrote it up as a default. Okay, well, you got to go talk to the department rep here, okay? I don't know how that got. John, take him right to Toller, will you please?
Oh.
He'll take you to Lieutenant Toller. I don't know. This was scheduled for 11. So, all right, here you go. Toller.
No, I mean,
People against Sadie. I'm sorry. Versus Emla Christian Sadie, 25M601926. Go ahead. I don't know what she's saying. Recommending dismissal. What does that mean? Counsel, your appearance?
Respectfully, Your Honor, just to clarify, I'm standing in for the attorney record. The first name is PRCENYSLAW. Last name is SADY.
Right.
Yes, Your Honor. It's the dismissal. One of the counts break violation. That's a dismissal. The other one is just a warning, Judge.
Yeah. Well, why is she writing it up as recommending dismissal?
I think she's requesting from the court a dismissal. We have no objection.
All right. I mean, they do things different now than they used to. You know that? I'm just going to go ahead and dismiss. It's clearly her intent. Dismissed motion of the prosecutor. All set. Thank you very much. Have a good one.
Thank you, Your Honor. You have a wonderful day to you and your staff. Thank you, Judge.
You too. Azim. People against Mohammed Abdul Azim, 25B7301-99.
John Graziani, key number 43387 on behalf of Mr. Mohammed Azim.
How you doing, sir?
Please identify yourself. Mohammed Abdul.
We're going to adjourn it a week, right?
That's correct, Judge.
The 13th, please. So this Judge Huston's at what time?
10:45.
At 10:45, okay?
Thank you.
Sir, you go down the hall and get your notice, all right?
Thank you.
Thank you. Shane Hankey. Shane Michael Hankey, 25F731143.
If it please the court, attorney Sharon Jones, T number 57113 on behalf of Mr. Hankey.
Good morning, Ms. Jones. Where is Shane Hankey?
He's in the CJC on screen.
Oh, thank you. Your name, sir? Are you Mr. Hankey? Is that Mr. Hankey?
I believe so, maybe not.
I haven't had a chance to check in the jail people yet, so I'm not sure who that is.
Sir, right there, the blonde haired guy. Can you look at me a second?
Yeah, me.
What's your name?
Aaron. Last name's Fletcher.
Okay.
Sorry, it's not him then.
We're going to have to get Mr. Hankey in here.
Your Honor, we can see if one of them can switch out for Mr. Hankey.
Okay.
Can you guys, one of you go ahead, Mr. Fletcher? Would
Can I
you
switch out?
Yeah, just tell him we'd like Shane Hankey in here. Shane Hankey.
You want me to tell them to get Shane Hankey?
Yeah.
Okay.
Charles Edward Baker, 13T607615.
Here, Deputy, someone. The judge is looking for a Shane Hankey.
Where's Charles Baker at?
He's in custody. He's right there.
Your name, sir?
Charles Edward Baker Jr.
All right. It looks like he has not been arraigned yet. I had him writted out for sentencing. I entered the conviction when you didn't appear in 2024. This is a 2013 case. You have the right to an attorney. I'll be more than happy to provide you with one at public expense. Would you like a lawyer to represent you, Mr. Baker?
Well, I sent a plea by mail to you guys.
I don't know. Yeah, I know. I don't know. I made the determination I was going to have you written out for sentencing.
I guess if I need a lawyer, then yeah, I guess I need a lawyer to explain it all to me.
How long are you in custody on other cases?
This is 6 months here.
When are you scheduled to be released?
April 9th.
When are you going to grow up?
Right now.
I don't know. It's kind of getting late in the game. What are you, 48 or 9?
I just turned 49 yesterday.
It's getting late in the game.
It's
Please do me a
ridiculous.
favor. Can you go online and confirm that he's going to have to come back, John?
Okay.
This was scheduled for 11. Have you, what time did you get here, Mr. McGee? I can't hear you. Why were you late? This
Boss wouldn't let me leave. I work right here in Shenandoah, and I had to wait until he had to pay off my manager.
Look, Lisa, can you figure out if he's in there until April?
Yeah, I'll look right now.
You guys responded to my plea by mail.
Mr. Baker, I don't want to talk about your plea by mail right now, okay? I get a little tired of plea by mails. You guys commit 49 different crimes and then you want everybody to run everything concurrent. So please don't. I'm in no mood to talk to you about a plea by mail on a case that's been going on since 2016. You got it? So talk to some other judge at some other court about plea by mails. I don't want to hear it.
I just got a letter from
Did you hear what I said? Listen to me clearly. I don't want to hear it.
My apologies.
John, I don't care how you do it. Toller either needs to come back or put him on Zoom and let him talk to this guy and he can fax one over or email one over, okay? Got to show up on time though, Mr. McGee, but I'm going to try to help you here, all right? So let me check into this one. You stay there. You mute yourself. Like Mr. Hankey, I'm going back to Hankey. Shane Michael Hankey, 25F731143FY. Okay. Counsel, your appearance again.
Thank you, Your Honor. If it please the court, Attorney Sharon Jones, P number 57113, on behalf of Mr. Hankey, who appears from the CJC. That definitely is Mr. Hankey.
Mr. Hankey, your name?
Shane Michael Hankey.
So we're doing this January 13th. They got it at 11 or 11:15.
11 should be fine, Your Honor.
Is that good, Lisa, for Judge Hudson?
Yes, that's fine.
Okay, so we'll do it January 13th at 11. We'll have your client rated out, okay?
Your Honor, could you consider a bond motion?
I mean, I didn't set the bonds.
Well,
I may have to get the prosecutor in here. Let me get the prosecutor in here. So she'll have a right to respond here, okay? Does he have any holds?
no, I believe no.
Do I? I'm gonna need the prosecutor in here, please. Thanks. Do I have a detective here from Flat Rock by chance? Lieutenant Rembes? Are you on this case? Good morning. I can always count on you. Your name?
Good morning, Your Honor. Detective Lieutenant Chris Rembes. Yes, I'm on this case with Mr. Hankey.
Okay, so I'm gonna let her argue bond and then you can feel free to weigh in. Your name?
Good morning, Your Honor. Not on behalf of people who.
Good morning again. Kind of busy this morning. I'm gonna let Ms. Jones, she wants to address bond.
Well, Your Honor, his priors are fairly old. This is a second offense for possession, I believe, and that was about 24 years ago, the original one. And then his other offenses are also kind of older. I think the most recent one maybe was about 2006. I think he does have a history of once missing a court date, but I think that was because he had briefly moved away and didn't get it, and then he contacted the court afterward, but never took care of it. But generally, he's appeared for all of his matters, and he does live locally. He works as a painter. He
stayed out of trouble for 20 years, and now he's back in the system. Let me do this. What do you guys have to say? I didn't set this bond. I know nothing about this case.
The discussion of the court, just note that he is a habitual one.
Lieutenant, what do you have to say? How much, what kind of drugs was this and how much did he have?
Yeah, it was methamphetamine. I can get you the amount here in 1 second.
Oh, what?
I apologize, Your Honor. It was cocaine, I believe, on this case with Mr. Hankey.
You shouldn't be talking, Mr. Hankey. You don't want to be admitting you had cocaine.
Sorry, Your Honor.
I didn't, come on. That's crazy. You might as well join the prosecution team. All right,
Yeah, and Your Honor, he has no current holds that I'm aware of.
see that. Do you live on Riverside Street, apartment C6?
No, I live in Riverside Street. It's apartment 3. I changed apartments.
Okay, what's the apartment address?
27070 Riverside Street, apartment 3.
Is it C3?
Yes. No. F3. F3.
How long you been in the county jail? Since the 29th?
Yeah, I was arrested the day after Christmas on the 26th.
You know what a big mistake this would be by not showing up, right?
Yes, Your Honor.
You know that these guys will come and get you and haul you out of your apartment if you don't.
Your Honor,
listen.
Yes.
You know how big of a mistake that would be, right?
Yes, Your Honor.
You know they would come and pick you up, and then I'm going to be sitting here, or Judge Heston, and then you're going to have about a $200,000 cash bond. You'll be sitting in there.
I do not want that, Your Honor.
Here's what I'm going to do. I'll reduce the bond, 25,000 PR. No alcohol, marijuana, or illegal drugs. No contact with prosecution witnesses. AA 5 times a week. You have to go in person. Every time you go, you have to have the form signed. He's already been printed and photographed and DNA and everything, right?
Correct, Your Honor.
All right. Defendant to test 1 time per week. You're to come into the courthouse today. If somehow, some way you don't get here by 4 o'clock, then I expect you to show up tomorrow. You're going to chemically test 1 time per week.
Okay.
Chemical tests, ETG. Okay?
Yes,
So you're
yes,
going to
Your
come
Honor.
into the courthouse and they're going to set you up for testing, but I'll reduce your bond. Don't make this, don't abscond.
I will not
problem.
let you or myself down.
All right. You're going to be in front of Judge Hudson next week. Good
All
luck.
right. Thank you.
Thank you, counsel. Thanks, Ms. Jones. Thanks,
Thank
Mr.
you.
Lieutenant. Have a good day.
Good day.
All right.
Judge,
I know. Yeah, I know. I'm getting
Mr.
backed up.
Baker?
Yeah, Charles Edward Baker.
Yes,
his
sir.
release,
133-607-615.
sorry, his release date is April, and I looked, he had other cases with Judge Hessen that she just did credit time served. So that's what he's referring to with the plea by mail letter.
Yeah, he sent me one in November, which is what?
She just sent him a letter for credit time served, so I think that's why he
I see.
got confused.
My apologies.
You're not apologizing. You're just trying to get out of jail, and I don't think you should get out of jail. You know that?
I'm not trying to just get out of jail. I'm trying to take care of everything.
Mr. Baker. I don't like it when people treat the system like this.
I understand that.
No, you don't understand how much I dislike this. It's so incredibly. Don't interrupt me. again.
I'm sorry.
Don't interrupt me again. It's incredibly disrespectful. I mean, honestly, I look at what's going on in the world and I think about our judicial system and how some people think that they're bigger than the system, and they're not, and none of us are, and none of us ever will be. And I can't stand the fact that I'm ready to let you out. but I shouldn't let you out. I could run these consecutive, you know.
I do know that, sir.
Give me a first page of a register. You never paid the restitution to the victim, did you?
No, sir. And to be honest with you, that wasn't the plea that I wanted to do. I did not want to plead guilty to that because at the time, the lawyer I had, court-appointed attorney, talked me into that and told me it was easier for me to do that. But I shouldn't have pled guilty to something I didn't do.
Judge Kirsten wouldn't have took the plea. I know Judge Kirsten, and he would not have taken your plea if you told him you were not guilty of this offense. You admitted to the facts contained, right?
Yes.
You didn't lie to the judge, did you? You didn't lie to the judge and tell him you did something that you didn't do. You wouldn't do that, would you?
No, sir.
Judge, the restitution is paid. He did make some payments.
Good. Well, that makes me feel better. He paid that? What are you in custody on?
I started a job for somebody and I couldn't get back to it and finish it. And they gave me a down payment.
I'm asking you what the charge is.
It's larceny.
Shocking. Do you have a case number on that?
I don't have it in front of me, no.
So how can I handle this? I'm going to give him credit for time served. I'm going to run them concurrent. He's going to serve 45 days.
Thank you.
I can just type up a commitment and send it over to Monroe.
And that's where you are, right, sir?
Yes, sir. I'm in the outpatient therapy class. I just started in Michigan Works yesterday. I'm a trustee.
45 days jail. That's to run concurrent with the time. And I'm just going to, unless you want to still see a lawyer, this is what I'm doing.
No.
It's going to run concurrent.
No, sir, I don't need to see a lawyer.
45 days jail. It's to run concurrent with the time being served in Monroe County. I really hope you change your life up. It can't be any fun. I mean, spending time in jail, running from the police, prosecutors, courts.
Especially when I have two granddaughters. Thank you, sir.
Good luck. Okay.
Thank you.
Now, which one do you have again, counsel?
Got three. I've got Oski, Thomas, and Craig.
What was the one that we were dealing with? Oh. All right. Okay, so I'm going to go ahead and call that one. Gabriel Christine Popovsky, 25W8388-188.
Early days there was Popovsky.
Ma'am, your name?
Gabriel.
So the charge is she failed to refrain from consuming alcohol. And it's obviously commensurate with an arrest. And they think that she had a 0.333 on her results. How is she going to proceed here?
She hasn't been charged yet, but I'd anticipate she likely will be. I would ask the court to accept it on conscience.
That's fine. I'll be happy to do that. So is the no contest plea going to be to violation of law, or is it going to be to failure to refrain from consuming alcohol? Ma'am, if you plead no contest, it has the same effect as a guilty plea. Do you understand that?
Yes.
If you plead no contest to this charge, I could revoke your probation. That'd be a non-technical violation, and you could be incarcerated for up to 90 days. Do you understand that? And did you sign, read, and understand the advice or rights form here today? If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
And you understand all your rights, correct?
Yeah.
To the charge that you violated a law. And you understand, again, I want to just cover this. I don't want you to feel uncomfortable. You understand that if you plead no contest, again, it has the same effect as a guilty plea.
Yeah.
To the charge that you violated a law on September 24, 25. How do you plead? No contest?
Yes. No.
All right. And I can refer to a report. You stipulate that there's a factual basis for this. Are you on probation or parole right now, besides to me?
No.
Anybody force you to plead no contest? All right, I'm gonna accept your plea of no contest to violating the law, being convicted of, or at least being not being convicted, but committing the offense, no contest plea to OUIL. How I'm concerned about this.
If I may, because we took a plea on 2 other matters, I guess it's probably a couple months ago.
Right.
And in the interim, I think things have been going relatively well. So we've got this very high BLC, but for that,
Shanna Soberling,
yes.
and you haven't violated?
Didn't you put me on it when you found out?
I know, but you haven't blown positive, you,
Been driving once a week too. And blowing.
let me do this. I need to take a recess. My staff needs to take a recess. Give me 5 minutes. I'll get Ms. Tessino out here, and I don't know what happened with the, okay, so just give me 5 minutes. Okay? John, we're adjourned PCC 2 weeks.
Sure.
Yeah, I know that. What,
Okay.
The other gentleman, what's your name?
Sam Patton.
Sam what?
Patton, Patton.
This is just a
That's-
mess today.
That's Mr. Cripp's case. I think Miss Silver is handling it.
Come on in here, Ms. Silver. Sam Oscar Patton Jr., 25B728924. Good morning, everybody. I don't know what has happened here. I think, good morning, Ms. Silver. How are you? Happy New Year.
Good, Judge. Happy New Year to you too.
All right, your appearance?
Yes, Gabi Silver appearing on behalf of Mr. Patton.
Mr. Patton, your name?
Sam Oscar Patton Jr.
Detective, your name?
Good morning, Your Honor. Detective Crystal Tulaz, Brownstown Police Department.
All right, so it says adjourn PCC 2 weeks. You guys want 2 weeks, right, Ms. Silver?
Yes, Your Honor.
All right, so sir, you have the right to a probable cause conference within 14 days of the
Can I
date of
get
the
a phone
arraignment.
number for Mr. Patton? We have no contact information for him.
Sure.
248-820-AA59.
Thank you. Okay, sorry. Go ahead. Sorry.
That's all right. Mr. Patton, you have the right to a probable cause conference within 14 days of the date of the arraignment. Your lawyer needs to get discovery, review it, and get prepared. She's asking for an adjournment for 2 weeks. If I grant that request, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes.
You waive that right.
Yes.
All right, I'll accept the waiver. PCC, you're going to be in front of Judge Heston on this, Ms. Silver. I'm just covering for. PCC will be January 20th at what time, Lisa?
9:30.
At 9:30, and the preliminary exam will be the 27th at
11:15.
at 11:15. So January 20th at 9:30 PCC, preliminary exam, January 27th at 11:15. Okay?
Okay. I have a quick question.
Okay, thank you.
Well, don't talk about the case. What's your
No, it's
question?
not about the case. It's about my bond.
No.
Do I still have my personal with the
Yeah, nobody
20
changed your bond, Judge. You were given a
Okay.
personal bond of $20,000. Why are you're in hold? You got to hold on something else, right?
Yes.
Okay, well, you got a personal bond on this, but you got to
Okay.
clear the other. Okay.
Okay. Thank you.
Good luck. Thanks a lot. Have a good day, everybody. All right.
Okay.
Thank you.
Where is, do you want to call Ms. Mohammed or Mr. Mohammed, whoever it is? I don't know who they're, Joy Mohammed and Mr. Flesher. I don't have his case on. Alicia Marie Craig, 25W8386858. Can you find out where Fleischer's case is, John?
That's it's a sentencing with I'm sorry, a pretrial with Mr. Graziani. So he's
Okay,
got to
so
get on
find
soon.
out what Chris, because tell me want to get that guy out of the county. Good morning, your name? Ma'am, your name?
Alicia Marcotte.
All right, so she pled to impaired driving. She was sentenced on November the 2nd. And here we are today on a violation of probation. And it is, the charge is failed to refrain from violating a law, allowing a suspended driver to drive. How is she going to proceed on this? Ma'am, if you plead guilty here, your probation on this case could be revoked. You could be incarcerated for 93 days. Do you understand that?
Yes.
And you decide, read and understand and advise of rights.
Yes, I
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that? All right. You understand all your rights?
Yes, sir.
Through the charge that you failed to refrain from violating a law, being convicted of allowing an unlicensed driver to drive on December 11 of 25, with the offense date being on November 20 of 25. How do you plead?
Guilty.
Did you get convicted in this courthouse? Were you convicted arising out of an offense of November 2025 of allowing a suspended person to operate on December 11 of 25?
Yes, sir.
Anybody force you to plead guilty?
I have.
When did I place you on probation?
Literally like a week before the
I didn't have much effect on you, did I?
No, you did.
Well, I must not have, because you wouldn't have been driving a week later, right? Come on,
Correct.
right?
You're right.
What did I do on that sentence? Were you in front of me on that case?
Yes, sir. Yes, sir.
Lisa, can you tell me what my sentence was, please? Or
Yeah, I can look.
please.
The sentencing for omissions have.
Well, I know, but I'm asking on the allowed unlicensed driver to drive.
The other judge. Judge Simpson. She put me on a payment plan. She added to your payment plan. I now got it in the mail yesterday, the slips, and I have to pay $150 total instead of the 40.
That's correct, Judge. Just put her on a payment plan.
So there was no other penalty.
No.
How much did she fine her?
Let me see. $275.
But this was you driving, right?
Yes, sure.
I'm gonna hope you're gonna take me more seriously. Anything?
Judge, I think this, apart from this, everything else is going on. It's a serious charge, which she's on probation due to. And I think so far all testing and those requirements are going okay.
Anything, ma'am?
I apologize. I will admit my wrongs and it will not happen again.
Pay costs of $50 and serve 6 hours of community service by January 31. Okay? So that you have the money to pay that?
How much?
50.
I can pay that, yes.
So you pay that now, and then you talk to probation, you're gonna have to do 6 hours or,
Thank you.
all right? Come on now. Comply with laws, will you please? Thank you. Have a good day. I don't know what else. If we don't have Fleischer ready and we don't have Fieldholler ready. What other one do you have?
You have Thomas?
Nadia Leanne Thomas, 25B1489438.
You're with us, Ms. Thomas. He's pleading guilty to both violations.
Your name, ma'am?
It's on.
I'll need Beth. She can just log in, tell her, John. You are going to, plead guilty, your lawyer tells me, to these violations of probation.
Yeah.
If you plead guilty here, since you have no prior technical violations, you could get 10 days. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. To the charge of failed to attend the court work program on December 13 of 25, how do you plead?
Yes.
To the charge of failed to submit the twice monthly testing as ordered on December 3 of 25, how do you plead?
Yes.
Did you fail to attend the court work program on December 13 of 25?
Yes.
Did you fail to submit the testing on December 3 of 25?
Yes.
Anybody forced you to plead guilty?
No.
Please accept it to those two counts. Let me see. She's not off to a good start. I just placed her on probation on November 19. She's missed the court work program and she failed the test.
Judge would say this, she had another work program day the following week, and she did do that. She had health issues on the 13th. She's going to need to reschedule at a minimum on that. And then with regard.
Did you go to a doctor?
No.
Did you contact the probation officer that day?
I lost her information.
Hang on. I just want to know if you contacted the probation officer that day. Did you?
Not that day. I have contacted her after that day.
What day did you contact?
Last week.
Last week. So 2 weeks after you missed the court work program, right?
But I went to the one after that, so I thought I would be able to do it. But
What about the chemical testing? Why didn't you show up for that?
I had went the next morning and I had to go to work and I worked the hour. That day I was working an hour away. So I was asking them to stay open until 8 o'clock and she's saying you can't get here by 7:45, then just come the following morning. So I went in the following morning.
Did you get a hold of Ms. Wise?
I did. Judge, I think the other part of that, I don't think she realized that she could have tested at an agency closer to where she was instead.
Yeah, I thought I could only go by my house because I was all the way and I was all the way out here and I stay in Warren, so I thought I could only go to the Warren location.
Say that again?
So drop for my test, I thought I could only go to the one by my house, which is in Warren. But I was working out here.
Working where?
I was doing delivery driving.
What do you mean out here? In Woodhaven?
Yeah,
You could have gone to DNA.
I didn't know that.
She didn't realize she could go to a different.
Because on my probation thing, that location was circled, so I thought that was my specific testing location to all go to.
All right. I don't know. Did you get a hold of her?
I did, Your Honor.
Have a seat 1 second. Melvin McGee Jr., 25W840861. You can have a seat right at the table there, ma'am. What's your name? What's this have to do with anything? Oh, you were, so they're gonna. Your speedometer was malfunctioning?
Yes, I got a recall. I'll be able to pull that up.
Wow. You were going 70 and a 40 though.
Yep.
Right?
You
You kind of know the difference between 70 and a 40, don't you?
Nobody else is on the road. I come in.
I know, but don't you know the difference between 70 and 40? Okay. I'm sure I believe that, but they're going to give you an expired plate and they're going to dismiss the speeding, right? Or equipment violation, rather. And then you're going to plead to expired plate, right? Lieutenant Toller, is that right? So he's going to plead to expired plate. He's going to plead to equipment violation. The speeding will be dismissed, right? Is that what you want to do?
Yes.
To the charge equipment violation, responsible or not responsible? And to the charge of expired plate, responsible or not responsible? Pleas are accepted on the equipment violation, $135. On the expired plate, $130. $265. You could go down the hall and take care of that. You're all set. I wish you well. Good luck. Speed's dismissed. Thank you. Thanks for coming back, Lieutenant. All right, John, those need to be represented. I need to take 5-minute recess, but I don't want to take one if I've got, where's Fletcher's file? Does Mr.
Miss Mohammed is here also for the sentencing. She has Spielhauer.
Right. Shannon Marie Fieldholler, 25T7288822. Okay, everybody's name?
Shannon Marie Philhauer.
Joy Mohammed on behalf of Shannon Philhauer. I'm sorry. Did I speak out of turn? My apologies.
No, you're fine. I thought we were going to try to get you into sobriety court. And somebody wrote no one available to discuss the sobriety court with defendant.
That's exactly what we discussed. I'm not exactly sure how
What
the
is
30.
that? What kind of noise is that? I feel like I'm at a hockey game or something. Who's got what going? Ms. Fieldholler, your name again, ma'am?
My name's Shannon Philhauer.
I thought we talked about sobriety court.
Well, we did, and I filled out the paperwork with the probation, there.
Filed your name?
I'm sorry?
Talking to the probation officer, director. Ms. Wild, your name?
Elizabeth Wilds, probation, Your Honor.
Who's writing in this? No one available to discuss sobriety court. Somebody should have followed up on this.
I have no idea who Miss Philhauer is or who wrote in the file, Judge. I haven't seen that.
Well, it's on a purple sticky note. No one available to discuss the sobriety court with the defendant at approximately 1 p.m. Emily early out at 10:30, Beth early out at 12:30. I don't know what even date we're talking about. Is it December 23rd?
Yeah, I didn't see that file or hear about that information at all, Judge.
Ma'am, what are you in custody on? Just this?
I believe my client has some other pending matters, but I'm not her attorney. So if she knows better, she might know better than me.
Do you have other cases that you're in custody on because you can't post bond?
I have several holds, and I was talking to you and my attorney about it in the courtroom slightly, that I do have holds in Detroit also where I'm going to have to do a sobriety court as well. So
well, we don't want you doing 2 sobriety courts.
Right. So
when is your next court date on those, ma'am?
They haven't started yet. I'm working with the county sheriffs in here for the Judge Holmes's sobriety court because I have 4 warrants out of Detroit. So I was hoping just to get a sentence on these charges as soon as possible.
Yeah, so you can run everything concurrent. I get it.
Yes. Thank you.
Yeah. I'm not stupid. All right, give me a first page of a misdemeanor record, 2 of them, will you? For 2 pages of misdemeanor. I don't need probation orders, just the register of action. I see no reason to put probation. I don't think you're trying. You know that? I mean, it seemed like first of all, counsel, have you had a chance to review the report? Are there any material additions, corrections, or deletions?
There are no materials, additions, or corrections. I have not had a chance to meet with my client because Wayne County Jail's elevator was down when I went over the holidays. But based off my conversations with my client, I didn't see anything that was out of line. The recommendation from probation department is in line with the sentencing agreement that we came up with.
There wasn't really a sentencing agreement, was there, or was there?
There was a sentencing agreement to a term of jail time for her 2 possession charges to be less than 1 year, and it was to the discretion of the court. The length.
Yeah, but okay. All right, so I've got count 1, use of meth, count 2, use of fentanyl. I mean, yeah, I vaguely remember talking about a year. Is there anything else you would like to tell me?
That you might
Either
think
one of you.
I'm not serious about this, but I am. Okay, I'm done with all of this. I am like older. I feel like if I'm getting old. I feel like if I don't take care of all this now, I won't make it back.
Listen, you got 13 warrants out for your arrest.
I know.
You've been fooling around with drugs since at least 2011. Let me just count the ways. 1, 2, 3, 4, 5. This one's 6. And then you have multiple warrants on drug offenses. 1, 2, 3, 4. And 2 counts of 2 different charges of drug paraphernalia. So you got, I don't know why you're doing this. I mean, I get the addiction thing, okay?
Yes.
I get the addiction thing. But you got a child, man.
I'm aware, and I could talk to you till I'm blue in the face to try to make you believe me, but I mean, all I can keep doing is keep trying. I mean, I don't know what else to do.
Well, I agree with that. I do agree with that. I do agree with that. I see no reason to, when is your next court dates scheduled, ma'am?
We haven't scheduled them yet. Like, the officers here are going to contact the courts and line up the court dates as soon as I get, because they want to see what this with these matters, what you guys were going to do with me to be able to start the sobriety court and to get rid of all these other holds.
On my math, she's got 43 days credit coming, counsel. Does that sound about right?
That's exactly my calculations as well.
All right. I'm going to just get rid of this pretty much. I'm not going to give you a year. 180 days, credit 43 on both counts. I'm not even going to order victims' rights and justice assessment. So you are to serve 137 days on these cases, and they will run obviously concurrent. They arise out of the same event. So 137 days jail, and that's it. No probation. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I'm sorry that we couldn't get you in our sobriety court. I really am. Good luck to you, ma'am. Thank you.
Thank you.
Thank you.
Now, do I have Mr. Why don't you see if call Graziani in here and see if we can get Fleischer out of here before the county takes him back, John?
Judge, he's in a breakout room. He just needs to join. The defendant needs to join the breakout room.
You join the breakout room, sir. I know, but I have got to take a couple of minutes. We've been on this bench. Everybody stay seated. So as soon as he's ready on that one, I'm taking that first. And then I'll come back and handle the rest.
I just need to know when Mr. Favorably likes you in the Department of Corrections.
Okay.
I can join that.
This is 24 DCCR 0751. Ms. Collier is on probation for the second-degree felony offense of aggravated assault with a deadly weapon. That probation was from October 7th of 2024, and we did a 10-year term in prison that was probated for 10 years, which we have now, I think, figured out, and I don't disagree with Mr. Kimler that this should have been a deferred probation instead of a straight probation. I'm going to do a little research on that, though, after today and figure out exactly, you filed a motion to quash. I'll take a look at that and figure out what our options are. as far as that issue. What we're here for today, regardless of all of that, Ms. Collier accepted responsibility, pled guilty to the offense, whether it was a straight or deferred, took a probation. The motion alleges that she's violated her probation by committing a new offense of assault causing bodily injury October 17th of 2024, not mailing in or reporting online for several months, not reporting address change, and just a little bit behind in court assessed fees. And Mr. Kimler has asked that a bond be set. Currently, there's no bond in this case. I think she's obviously entitled to one based on the nature of what's going on. Mr. Nichols, what's the state's position?
I just asked that the bond be sufficient to secure her appearance in court, Your Honor.
What's the status of that?
I believe it's a pending misdemeanor assault.
This is out of care.
Is it?
It says Jefferson County.
Is it? Okay.
Yes.
Did that happen in Jefferson County? UK? Okay, yes, it's just.
So that's still pending?
I looked at it yesterday, Judge. I think it is still pending, unless I'm mixing it up with another summer case.
So, Ms. Collier, I'm just going to ask you a few questions so I know some information before I do this. Best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right. So, Ms. Collier, where, if released, will you be living?
22nd 30th Street, apartment 8. My boyfriend bought me an apartment because I was coming here to myself.
Speak up.
My boyfriend had bought me an apartment because I was coming.
Hold on a second. Y'all, I'm having a hard time hearing if today for some reason and the voices are low. So
Speak up.
Sweegham, apartment A?
Yes, apartment
Okay. 8. Gotcha. Okay. And who else will be living at that apartment?
Jamal Guidry, my boyfriend. He bought the apartment just so that I could come move back.
And is Mr. Guidry in any kind of trouble?
No, ma'am. He's clean, no criminal record, no like that. He's a working man. He comes from.
Is that in Port Arthur or Beaumont?
It's in Beaumont. It's Mosaic Apartments.
Okay. So where were you living?
2010 East 7th Street, my mom's house where I had reported to my probation officer in South Dakota.
Oh, in South Dakota?
Yes, ma'am.
Okay. All right.
I think she had permission to be there.
Yeah.
Yeah. She was reporting here online. That's why I knew she was somewhere else.
And I have a.
And good morning, probation's here as well. It looks like other than failing to report online for the beginning of this year or last year, we're 2026, 2025. An address issue, other than that new offense, things were going okay where she was in South Dakota?
No, ma'am. She, South Dakota actually rejected her case because she was not on the list of the original address, which was your mom's. Right, so they rejected her case. She had to come back. She came back, but then she went back without permission. That was
The problem, okay. So here's what I'm going to do, Ms. Collier. I'm going to grant Mr. Kimler's motion to set a bond in your case. I'm going to set the bond in your case. Well, let me get a little more information so I can make sure I have all this right. Who is the complaining witness in the 2024 misdemeanor case?
It's a acquaintance, Judge. I don't think it was a family member or somebody she got an altercation with, actually drove over with her car. Was the original offense.
What's the name of that person? Do we know?
I have it right here. Daisy Anna Brown.
Say it again.
Daisy Anna Brown.
See. All right, so here's what I'm gonna do. I'm not going to make the bond real high because I am also going to require that you get a GPS monitoring device and so that obviously we'll know where you are with some other conditions. And so I'm going to set the bond in your case at $10,000. Okay. I'm going to order as a condition of that bond, if you make it, that you remain in Jefferson County, Texas. You cannot leave Jefferson County, Texas. Hold on, just listen. Okay. You will be required to wear a GPS monitoring device. You will be reporting in person here in Jefferson County. There's no leaving the county. If you leave the county, you're back in jail and we're on a whole different path. Do you understand? You will live at 2730 Sweetgum, apartment 8 in Beaumont, unless you give notice to probation and they let me know and I approve somewhere else for you to live. So you can't just move and then tell us. You need to let them know and then they'll let me know or let Mr. Kimler know. I want to know where you're going, who you're with, and those kinds of things. On probation, you cannot be around anybody else that's on probation or charged with an offense. And so you need to get a job, go to work, go to probation, go home.
Yes, ma'am.
That's it. Do you understand?
Yes, ma'am.
And then I will set the case for just another, maybe no more than a normal reset. And we'll take a look at what our options are on getting the issue worked out, if possible, with regard to the type of probation. And so, Mr. Nichols, if you'll do some research into that as well, see what our options are, and I'll get Mr. Florence to take a look at it as well. All right? You can go back with the bailiff.
Thank you.
Would you also run and go let her know, part of that bond condition is that she has no contact with Daisy Ann Brown before they take her back? I didn't say it, but I'm making it to order. Thank you. Wayne Cummings.
This is just, we're asking for a bond on this one.
You're whispering again.
I'm sorry, we're asking for a bond on this.
Yeah, that's what we're here for. Are you Wayne Cummings? Mr. Cummings, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And so this is cause number 18-29640. Mr. Cummings is on probation for the offense of manslaughter. A motion to revoke community supervision has been filed, and Mr. Kimler's filed a motion asking that I set a bond. Looks like the date of the probation was from October 22nd of 2018. A 10-year term in prison, probated for 10 years. New offense alleged in that motion is a driving while intoxicated, October 5th of 2025 in Orange, at a location other than his residence at 4:15 a.m. on October 5th in Orange, and that he was intoxicated on that date and behind in court-assessed fees. Mr. Kimler, you may proceed.
Your Honor, first observation is Mr. Cummings did turn himself in. This wasn't one where he headed for the tall grass when he found out he had an MTRP. He did turn himself in. I understand. I think this is straight probation. It's not entitled to a bond. However, with the Orange, and of course, Mr. Smith is familiar with Orange County. It may be a while before that DWI is filed, so I don't know how long it's going to take for the state to be in a position to try to prove that up. So we were just asking for a bond pending this position if they're going to proceed on the DWI. obviously they could proceed on the administrative violations.
Mr. Smith?
My concern, Judge, is firstly, the manslaughter was basically a DWI where he hit somebody and killed them. He had issues. Safety was a recommendation for the original probation to go through in the PSI. This new offense, the allegations apparently show he was out at 4 a.m. and was intoxicated driving. And so I would have reservations and concerns. I think there's been a relapse, and he's not actually entitled to a bond. It's a straight probation versus deferred. So we would be opposed to a bond.
Do you know the status of the Orange County case?
I don't, Judge.
I don't think it's been filed yet, 100%. I checked before.
If it was just knowing how they work over there, if it was just alcohol, they would have already probably had the results.
Y'all are just guessing. Is there a way for us to find out? Is there any kind of hold on him?
If you want to hold it for a minute, I can call the DA's office and find out.
Yeah, let's do real quick, and we'll just do it real quick. Just have a seat, sir. And there's not, I'd like to know what that is.
They threw it away.
Okay. Is there Mr. Bynum? Mr. Cashin? Oh, I don't think he's. Mr. Cashin's going to zoom in and he hasn't zoomed in yet. So I'm going to hold Mr. Williams' case for just a minute.
Your Honor, I know he intends to zoom in. I talked to his son yesterday, but by a note, his brother died on December 1st, and then on December 2nd, he had emergency surgery.
Right, he contacted us and said he's going to Zoom. So let me just hold it till he does. Thank you. See, Mr. Macon?
Yes, Your Honor.
You have Calvin Hawkins.
Yes, Your Honor.
It's a bond hearing.
He's over in the side here.
Okay, well, as soon as they get him over, we'll take care of that.
Okay, thank you.
Mr. Matusko and Michael Brasher. Good morning. Morning.
Happy New Year, Judge.
Happy New Year.
How are you? Good.
He is on the other side. They're getting them. Okay. We'll take care of that as soon as, what about Michael Victoria? Okay.
No, he's on the other side.
He is? Okay. But if they can get him too for Mr. Matuska, we can get them done.
And Now approach, Your Honor.
Yeah.
I have
to Herbert DeBlanc. He got a long criminal history. It's an old case. He's been in prison since 21. So we're trying to figure out. He was actually, according to me, he's in prison at the time they alleged the deal. So Tommy wants a week so we can check it to make sure.
Mr. Coleman, on Herbert DeBlanc, you need a little time to check on that
Correct.
TDC time.
There's some dates.
Okay.
Rule in or rule out.
All right, let's reset, Mr. DeBlanc.
1 or 2 weeks, Judge, I think would be sufficient. Whatever's easiest.
Well, it's either 1 or 3.
Okay.
I'll defer to the court. I don't need much time.
In MLK Day.
Monday, we have Tuesday.
Oh, yeah. Okay. 2 weeks is good. Never mind. I was just thinking of from yesterday.
Yes.
And then on Marquise Jones.
He's ready whenever.
Oh, I'll take care of that.
I think, well.
I got it.
Oh, yeah, it's ready. All right. It's
Mr. Nichols on Marquise Jones. Good morning. Are you Marquise Jones? And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, in cause number 21-37263, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 23rd of 2022 for the offense of theft of material, and that was a state jail felony, and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of evading arrest on June 20th, 2024 in Harris County, Texas. And is that true or not true? And then count 2 alleges that you were at a location other than your residence at approximately 1:30 a.m. June 20th of 2024. And is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily? And did you plead true to those counts because they're actually true? Speak up, please. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
And I think I said your plea of guilty instead of true, but your pleas are true. Anyway, all right. So I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of material, aluminum. I guess it goes on, aluminum, bronze,
Aluminum,
copper.
Bronze, copper. They were cutting catalytic converters.
And so find you guilty and sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir, and thank you for being here, sir. Oh, my nose is sneezing right there, and now I'm sneezing, sounds easy. Perfect. Thank you very much. Mr. Kimler, back on Who is it?
Cummings.
Mr. Cummings? All right, again, you're Wayne Cummings, right? And Mr. Smith, what did you find out about that Orange County
I
case?
spoke with staff at the district attorney's office. They did not.
Can y'all, if you're talking about a case, keep it down. If you're not, please stop.
They have not received the case. Found out the agency, it's Orange Police Department that made the arrest. He said, the person I spoke to said that it normally takes about 6 months to get this in. It's going to be a misdemeanor, it looks like, based on looking at criminal history and his PSI. And they thought that as well.
Okay. So then that's really the main issue, obviously, in this motion, out past curfew and that
That was the thing that
offense.
concerned me, was the time of day.
Sure. So here's what I'm going to do. I'm going to grant the motion to set a bond.
Scram device, Your Honor, or?
Hold on. I don't want Mr. Cummings driving at all. All right, so that's going to be a condition of this bond. You're not allowed to drive a vehicle ever while you're on this bond. No one's vehicle, not yours, not anyone else. For any reason, you're not allowed to drive. Do you understand? I'm going to set the bond in your case at $25,000. Again, condition of that bond is no driving. Also, a condition of that bond is going to be that you are required to wear a GPS monitoring device at all times and remain. Do you live in Orange or do you live in Beaumont or Port Arthur? Where do you live?
I was in housing out there in Orange.
When you go home, if you make a bond, where's home? Where are you going to be? In
Maybe-
Orange?
maybe. I'm trying to figure out, I don't know where I'm gonna go.
Okay.
I can get back with you on that.
So what I'm going to do is require a GPS monitoring device and that you remain in either Orange or Jefferson County. You need to let your bondsman know they're going to require an address so that I know where that GPS is you're supposed to be. And obviously you're still on probation. The same curfew applies. You're not to be out of your house past 10 o'clock at night. And also going to require I think it's probably because I'm requiring the GPS, a little more cost effective to do the handheld breathalyzer. So you're going to be required to have the handheld breathalyzer. You are not to drink alcohol ever. If you test positive, if you miss blowing throughout the day, it's a thing where you have to blow randomly throughout the day. It's going to tell you when probation and your bondsman can go over that with you also. But if you test positive for alcohol, your bond's going to get right back up and you'll be back in jail. Do you understand? If you need some help, you're still on probation. Go to your probation officer. Say, look, I relapsed. I was drinking. What can I do while you're out on this bond if you make it? Okay. Anything else?
You have to report to probation.
Anything else? Anything else, Mr. Smith, that you can think of?
You have to report to probation.
Okay, you can go back with the bailiff. Mr. Matuska, on Mr. Brasher. Hi, sir, you're Michael Brasher. And this is 23 DCCR 0944. Mr. Brasher's case is set for trial to begin with jury selection next Monday. And what is the announcement?
State's ready to try this.
All right, then this will be the number one case. There was only two or one really left over from yesterday. And so I can go ahead and let y'all know it will be the number one case. After today, there will be no plea agreements. If something gets worked out before you leave today, let me know. Otherwise, we'll see y'all Monday and we'll begin jury selection at 1 o'clock. All right, thank you. You can go back with the bailiff. I don't know what I did with that other. Okay, let's see. And then Mr. Matuska, you have Michael Victoria. Good morning, sir. Are you Michael Victoria? And this is cause numbers 21-36410 and 21-36411. Mr. Victoria is charged with murder in each of these cases. Mr. Matuska, what is the announcement?
Your Honor, at the last setting, I informed the court that it had about 48 DVDs in this case.
Right.
This morning I checked, I'm on 23, I'm about halfway there. And that also includes hundreds of documents I've gone through. So I'm getting close, but I would ask for one more regular recess.
Mr. Smith?
Judge, I completely understand this is almost a bucket just with the two cases.
Right. All right, so I'll do a normal reset to give Mr. Matuska some time to complete all of that discovery, come out and visit with you about it. We'll see if we can get an announcement at the next court date possibly. Okay, you can go back with the bailiff. Passions.
Yes.
Yes. I'm sorry.
Becky, can you just tell me a little bit of the family that particular murder case or here? I was going to try to explain things.
Okay. Let's see, Calvin Hawkins, Mr. Macon. See, Mr. Coleman, this is yours as a bond hearing.
No, I filed a response to the motion.
Okay, give me just a second. Hold on. Anna, I just got, do I hit yes or no? I got a script error. Just exit out.
No.
Here, I'll print out a copy for,
I can summarize it. Normally, after I e-file it, I email it to the court and copy the court on that. We get a chance to do this.
it's okay. We'll take a look at it real quick. So, sir, are you Calvin Hawkins?
No.
And this is 24 DCCR 1160. Mr. Hawkins is charged with unlawful possession of a firearm by a felon. Looks like the bond is currently set at 100,000. There was a court date, March 31st, that Mr. Hawkins did not appear, and so there was a bond forfeiture, and the bond was raised to 100,000 at that time based on that. And then Mr. Macon looks like was hired, filed motions and letter of representation in October. So here is Mr. Macon, the state's. I don't know why it printed like this. Oh my gosh. No, I mean, I printed two copies and it printed like 1122. It hasn't done that in the past, ever, when I've done I've never seen it do that. It never has done it to me. Okay, so the state filed a reply to Mr. Macon's motion asking for a bond to be reduced. Let me take a look. Go ahead.
Just a summary.
Yeah.
Page 2, it's refers to the defense criminal history, and also on page 2, the very bottom refers to jail write-ups, and that's essentially the state's, what the state would ask the court to take into consideration if you are so inclined to reduce the defendant's bond. Criminal history, including 4 previous felony convictions, 1 for burglary, a felony theft, the possession of cocaine, and a felony marijuana. And he's been also written up by jail staff for possessing contraband in jail and failing to follow and disrespecting the rules of staff in the jail.
All right, thank you, Mr. Coleman. And I am getting copies of any jail incident reports.
I've attached a couple of those reports to my motion. For my reply.
Oh, okay, I see those. Would you check and see if there's anything since December 3rd, please?
Yeah.
Okay. So the prior, all of those offenses, the burglary, theft, possession of cocaine, and felony possession of marijuana, all of those are felony offenses and convictions, correct?
That's my understanding.
Mr. Macon, you may proceed.
Yes, Your Honor. First off, Mr. Hawkins, you're unable to make the 100,000.
Hold on just a second. Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead. I'm sorry, Mr. Macon.
Would you state your name, please? And you've been unable to make the $100,000 bond, correct?
Yes.
Okay, do you have family and friends that were a reasonable bond be set that you could make?
Yes.
Okay, now you understand you're from Florida, so if you make a bond, you'd have to stay in Jefferson County.
Yes.
And you have friends that you would live with here in this area?
Yes, sir.
Okay. Now, you turned yourself in once you learned there was a warrant for your arrest, didn't you?
I didn't know I had a warrant for my arrest.
But when you learned, you turned yourself in.
Yes.
Okay. Do you understand that you also would be required to wear a GPS monitor and probably a drug patch or anything like that? You comply with all those conditions. And whatever other conditions you were given, you would do. Okay, now with respect to this contraband, the September 26th, they were Tylenol pills, right?
Yes. I just didn't take them.
You were given them by the jail staff and didn't take them. Then December 3rd, and December 3rd incident was you having your jumper down or something. But you didn't have a knife or anything like that or anything like that. In other words, they wrote you up for refusal to follow written or oral directives. But you didn't jump anyone or beat them up or anything like that.
Well, I don't even recall that write-up. I didn't even.
Okay. I have nothing further on it.
Okay, and I'm reviewing the probable cause as well. Give me just a second.
Your Honor, I could ask some questions.
I need to read the probable cause. If you'll just give me a minute, please.